The Senate will come to order. Mr. Carpenter, please call the roll.
Senators Bridges, Cook, Coram, Court, Crowder, Danielson, Donovan, Finberg, Fields, Foote, Gardner, Janal, Gonzalez, Hill, Heisey, Holbert, Lee, Lundeen, Marble, Moreno, Pedersen, Priola, Rankin, Rodriguez, Scott, Smallwood, Sonnenberg, Story, Tate, Todd, Williams, Winter, Woodward, Zenzinger. Mr. President.
Here. With 35 present, 0 absent, 0 excused, we have a quorum. Senator Gonzalez, would you please lead us in the Pledge of Allegiance?
Thank you. Colleagues, audience members in the gallery, please join me for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Approval of the journal. Senator Danielson.
Thank you, Mr. President. I move that the reading of the Journal of Monday, March 11, 2019 be dispensed with and that the journal be approved as corrected by the Secretary.
Mr. Minority Leader.
Thank you, Mr. President. Pursuant to Senate Rule 14B, I object to the motion and ask that the journal be read at length as corrected by the Secretary for Monday, March 11.
You have heard the motion. All those in favor say aye. All those opposed, no. The noes have it. Motion is lost. The Senate will stand in a brief recess. Mr. Minority Leader.
Thank you, Mr. President. Again,
Excuse me, Mr. Minority Leader. The Senate will come back to order. Mr. Minority Leader.
Thank you, Mr. President. Pursuant to Senate Rule 14B, which states, before proceeding to any other order of business each day, the journal of the preceding day shall be corrected and approved. On any day, the journal for the preceding day shall be read at the request of any senator. No corrections of the original journal after it is approved shall be made without consent of the Senate. I object to the motion and ask that the journal for Monday, March 11, 2019 be read at length as approved by the Secretary.
Mr. Carpenter, please read the journal at length.
Senate Journal, 67th day, March 11, 2019, page 431. Senate Journal, 72nd General Assembly, State of Colorado, first regular second. 67th Legislative Day, Monday, March 11, 2019. Prayer by Senator Bridges, called to order by the President Pro Tem at 10 o'clock a.m. Roll call, present 34, excused 1. Todd, quorum. The President announced a quorum present. Pledge by Senator Gonzalez. Reading of the journal. On motion of Senator Danielson, reading of the journal Friday, March 8, 2019 was dispensed with, and the journal was approved as corrected by the Secretary. Senate Services Report, correctly printed Senate Bill 189, 190, and 191, correctly engrossed Senate Bill 141, 151, and 152. Senate Resolution 4, correctly re-engrossed Senate Bill 77, correctly re-revised House Bill 1083 and 1148, correctly enrolled Senate Bill 35, 46, 49, 68, 105, and 128. Introduction of bills, first reading. The following bill was read by title and referred to the committee indicated. Senate Bill 192 by Senators Winter and Priola, also Representatives Jackson, concerning the creation of an enterprise that is exempt from the requirements of Section 20 of Article 10 of the state constitution to administer a fee-based waste diversion grant program, local government. Third reading of bills, final passage, consent calendar. On third reading, the titles of the following bills were publicly read, the reading at length having been dispensed with by unanimous consent. Senate Bill 141 by Senators Donovan, also Representatives Roberts, concerning the authority to create an entertainment district and in connection therewith authorizing an entertainment district within a county or city and county and permitting an optional premises to be included in an entertainment district. The question being, shall the bill pass? The roll call was taken with the following result. Page 432, Senate Journal, 67th day, March 11th, 2019. Yes, 34. No, 0. Excused, 1. Absent, 0. Bridges, yes. Cook, yes. Quorum, yes. Court, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundeen, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, yes. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, yes. Tate, yes. Todd, excused. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. Majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added Lundeen, Priola, Tate, and Woodward. Senate Bill 152 by Senators Williams, A, also Representatives Duran and Arndt, concerning the continuation of the Public Safety Communications Subcommittee and in connection therewith implementing the recommendations contained in the 2018 Sunset Report by the Department of Regulatory Agencies. The question being, shall the bill pass? The roll call was taken with the following result. Yes, 34, no, 0, excused, 1, absent, 0. Bridges, yes. Cook, yes. Quorum, yes. Court, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundeen, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, yes. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, yes. Tate, yes. Todd, excused. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. Majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added Tate. Senate Bill 151 by Senators Bridges, also Representatives Exum, concerning the continuation of the Emergency Planning Subcommittee and in connection therewith implementing the recommendations contained in the 2018 Sunset Report by the Department of Regulatory Agencies. The question being, shall the bill pass? The roll call was taken with the following result. Yes, 34, no, 0, excused 1, absent 0. Bridges, yes. Cook, yes. Quorum, yes. Court, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundeen, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, yes. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, yes. Tate, yes. Todd, excused. Williams, yes. Winter, yes. Woodward, yes. Zenzinger, yes. President, yes. Majority of all members elected to the Senate having voted in the affirmative, the bill was passed. Co-sponsors added Crowder and Tate. Committee of the Whole. On motion of Senator Rodriguez, the Senate resolved itself into the Committee of the Whole for consideration of general orders, second reading of bills, consent calendar, and Senator Rodriguez was called to act as chair. Senate Journal, 67th day, March 11th, 2019, page 433. General orders, second reading of bills, consent calendar. The Committee of the Whole, having risen, the chair reported that the following bills, reading at length having been dispensed with by unanimous consent, had been considered and action taken thereon as follows. House Bill 1137, Representatives Wilson and Valdez D., Buckner, also Senators Priola, Pedersen, concerning supporting high school students' interests in early childhood education through the Teacher Cadet Program, ordered, revised, and placed on the calendar for third reading and final passage. Senate Bill 168 by Senator Lee and Gardner, Cook, Foote, Rodriguez, also Representatives Weissman and Harrod, Snyder, Soper, Van Winkle, concerning implementation of recommendations of the Committee on Legal Services in connection with legislative review of rules of state agencies. Amendment number 1, Legal Services Committee Amendment. Printed in Senate Journal, March 7th, page 407, and placed in members' bill files. As amended, ordered, engrossed, and placed on the calendar for third reading and final passage. Senate Bill 148 by Senators Heisey and Sonnenberg, Quorum, Donovan, and Janal. Also Representatives Valdez D. and Catlin, concerning the continuation of the Seed Potato Advisory Committee and in connection therewith, implementing the recommendations contained in the 2018 Sunset Report by the Department of Regulatory Agencies. Ordered, engrossed, and placed on the calendar for third reading and final passage. Senate Bill 147 by Senators Heisey and Sonnenberg, Quorum, Donovan, and Janal. Also Representatives Valdez D. and Catlin, concerning the continuation of the Seed Potato Act and in connection therewith, implementing the recommendations contained in the 2018 Sunset Report by the Department of Regulatory Agencies. Ordered, engrossed, and placed on the calendar for third reading and final passage. Adoption of the report of the Committee of the Whole. Consent calendar. On motion of Senator Rodriguez, the report of the Committee of the Whole was adopted on the following roll call vote. Yes, 34. No. 0. Excused. 1. Absent. 0. Bridges. Yes. Cook. Yes. Quorum. Yes. Court. Yes. Crowder. Yes. Danielson. Yes. Donovan. Yes. Finberg. Yes. Fields. Yes. Foote. Yes. Gardner. Yes. Janal. Yes. Gonzalez. Yes. Hill. Yes. Heisey. Yes. Holbert. Yes. Lee. Yes. Lundeen. Yes. Marble. Yes. Moreno. Yes. Pedersen. Yes. Priola. Yes. Rankin. Yes. Rodriguez. Yes. Scott. Yes. Smallwood. Yes. Sonnenberg. Yes. Story. Yes. Tate. Yes. Todd. Excused. Williams. Yes. Winter. Yes. Woodward. Yes. Zinzinger. Yes. President. Yes. The Committee of the Whole took the following action. Passed on second reading, Senate Bill 168 as amended, Senate Bill 148, Senate Bill 147, House Bill 1137. Committee of the Whole. On motion of Senator Rodriguez, the Senate resolved itself into the Committee of the Whole for consideration of general orders, second reading of bills. Senator Rodriguez was called to act as chair. Page 434, Senate Journal, 67th day, March 11, 2019. General orders, second reading of bills. The Committee of the Whole, having risen, the chair reported that the following bills had been considered and action taken thereon as follows. House Bill 1172 by Representatives Weissman, Harrod, Snyder, Soper, Van Winkle, also Senators Gardner and Cook, Foote, Lee, Rodriguez, concerning an organizational recodification of Title 12 of the Colorado Revised Statutes and in connection therewith, limiting substantive changes to those that conform similar provisions to achieve uniformity, eliminate redundancy, or allow for the consolidation of common provisions, or that eliminate provisions that are archaic or obsolete. At the request of Senator Cook, the bill was read at length, laid over until Wednesday, March 13th, retaining its place on the calendar. All in motion of Majority Leader Finberg, and with a majority of those elected to the Senate having voted in the affirmative, the balance of the general order's second reading of bills calendar, Senate Bill 182, House Bill 1113, Monday, March 11th, was laid over until Tuesday, March 12th, retaining its place on the calendar. Adoption of the report of the Committee of the Whole. On motion of Senator Rodriguez, the report of the Committee of the Whole was adopted on the following roll call vote. Yes, 34, no, 0, excused, 1, absent, 0. Bridges, yes. Cook, yes. Quorum, yes. Court, yes. Crowder, yes. Danielson, yes. Donovan, yes. Finberg, yes. Fields, yes. Foote, yes. Gardner, yes. Janal, yes. Gonzalez, yes. Hill, yes. Heisey, yes. Holbert, yes. Lee, yes. Lundeen, yes. Marble, yes. Moreno, yes. Pedersen, yes. Priola, yes. Rankin, yes. Rodriguez, yes. Scott, yes. Smallwood, yes. Sonnenberg, yes. Story, yes. Tate, yes. Todd, excused. Williams, yes. Winter, yes. Woodward, yes. Zinzinger, yes. President, yes. The Committee of the Whole took the following action. Laid over until Wednesday, March 13th, House Bill 1172. Laid over until Tuesday, March 12th, Senate Bill 182, House Bill 1113. On motion of Majority Leader Finberg, and with a majority of those elected to the Senate having voted in the affirmative, the balance of the calendar of Monday, March 11th, was laid over until Wednesday, March 13th, retaining its place on the calendar. Consideration of House amendments to Senate bills, Senate Bill 32. Consideration of governor's appointments, consent calendar. Members of the Board of Real Estate Appraisers, members of the Colorado Water Resources and Power Development Authority, members of the Rocky Mountain Low-Level Radioactive Waste Board. Introduction of bills, first reading. The following bills were read by title and referred to the committees indicated. Senate Bill 193 by Senators Janal and Lee Gardner, concerning the continuation of the Colorado Medical Practice Act and in connection therewith continuing the Colorado Medical Board, eliminating the 60-day limit on the pro bono license, repealing of the requirement that a letter of admonition be sent to licensees by certified mail, and updating language and making technical amendments. Judiciary. Senate Journal, 67th day, March 11, 2019, page 435. Senate Bill 194 by Senators Garcia and Zinzinger, also Representatives Froelich and Van Winkle, Byrd, concerning the addition of Colorado State University Global Campus as a designated institution of higher education for purposes of tuition assistance for members of the National Guard, state veterans, and military affairs. House Bill 1178 by Representatives McLaughlin, Van Winkle, Geithner, also Senator Donovan, concerning the name simplification of Western State Colorado University to Western Colorado University Education. House Bill 1191 by Representative Arndt, also Senator Donovan, concerning the ability of a farm stand to be operated on a principal use site of any size land area regardless of whether the site has been zoned by local government for agricultural operations, agriculture, and natural resources. House Bill 1198 by Representatives Valdez A. and Valdez D., also Senators Bridges and Priola, concerning the powers and duties of the Electric Vehicle Grant Fund, Transportation and Energy. House Bill 1200 by Representatives Arndt, also Senators Bridges and Quorum, concerning the point of compliance related to the treatment process involved in treating reclaimed domestic wastewater for indoor non-potable uses within a building where the general public can access plumbing fixtures that are used to deliver the reclaimed domestic wastewater local government. Signing of bills, resolutions, memorials. The President has signed Senate Bill 19 and 29, Senate Resolution 4, House Bill 1034, 1047, 1063, 1077, 1084, 1100, 1175. Delivery to the Governor for signature on Friday, March 8, 2019 at 5:50 p.m. Senate Bill 44, 57, and 69. Letters, March 11th, 2019, the Honorable Leroy Garcia, President of the Senate, Colorado General Assembly. Mr. President, earlier today, Senator John Cook asked for House Bill 1172 to be read at length. For approximately 2 hours, the Senate reader, as supported by Senate staff, began to read that bill. At some point thereafter, as many as 5 laptop computers were utilized to read the bill at a pace that was well beyond the ability to comprehend. Mr. President, I refer you to the Constitution of the State of Colorado, Article 5, Section 22, reading and passage of bills, which states every bill should be read by title when introduced and at length on 2 different days in each house, provided, however, any reading at length may be dispensed with upon unanimous consent of the members present. Senate Rule 40A, Parliamentary Authority, stipulates that the latest edition of Mason's Manual of Legislative Procedure shall govern the Senate in all cases in which it is not inconsistent with these rules and the joint rules of the Senate and the House of Representatives. Mason's Rules of Order, Section 723, states a substantial compliance with the constitutional requirement as to the reading of the bills is generally sufficient, although it has been held that the requirement of reading the bill on different days is mandatory. Mandatory requirements must be complied with. Page 436, Senate Journal, 67th day, March 11th, 2019. Mr. President, I appreciate our conversation earlier today, during which I made the request to slow the reading machines to a pace that would be comprehensible. My understanding is that you view the current pace to comply with the state constitution. I disagree. Senate Rule 16E says, any senator shall have the right to protest or remonstrate any action of the Senate, and such protest or remonstrance, with reasons therefore, if reduced to writing, shall without alteration or delay be with the consent of the Senate, entered in the journal if the protest or remonstrance is not personal in its nature. Therefore, I offer this letter as protest to the manner, specifically the speed at which House Bill 1172 was read at length today, per Rule 16.3. I ask that this letter be entered into the journal. Respectfully yours, signed Chris Holbert, Senate Minority Leader, C.C. Cindy Markwell, Secretary of the Senate. On motion of Majority Leader Finberg, the Senate adjourned until 9 a.m. Tuesday, March 12, 2019. Approved, Leroy M. Garcia, President of the Senate. Attest, Cindy L. Markwell, Secretary of the Senate.
Senator Danielson.
Thank you.
You recognize me.
Oh, I'm sorry.
That's all right. Thank you, Mr. President. I move that the reading of the Journal of Monday, March 11th, 2019 be dispensed with, and that the Journal be approved as corrected by the Secretary.
You have heard the motion. Is there any discussion? Senator Gardner.
Thank you, Mr. President, and my apologies to the senator from Wheat Ridge. I thought the motion had already been made. I noted as the reader was reading, and we thank him for his service to this body, that at page 434 of the journal, line 13, in reference to House Bill 1911-72, the journal states, at the request of Senator Cook, the bill was read at length. I believe this to be inaccurate and have handed the Secretary a requested correction to, at page 434, strike line 13 and substitute the words, Senator Cook requested the bill be read at length, period. The difference there being that Senator Cook requested the bill be read at length. I do not believe that what was done yesterday complies with constitutional requirement that a bill be read at full, or as commonly referred to as at length, and I request that correction, Mr. President.
Is there further discussion? Senator Moreno.
Thank you, Mr. President. Colleagues, in my estimation, the bill was read at length, and I encourage a no vote on this request.
Is there any further discussion? Senator Gardner.
I request a recorded vote, Mr. President, on this request of correction for the reading and the reading of the journal.
Just to be clear, Senator Gardner, you're requesting a roll call vote, correct? That's correct. A roll call vote has been requested on the correction. Mr. Carpenter, please poll the senators.
Senators Bridges, Bridges, no. Cook, Cook, aye. Quorum, Quorum, aye. Court, Court, no. Crowder, Crowder, aye. Danielson, Danielson, no. Donovan, Donovan, no. Finberg, Finberg, no. Fields, Fields, no. Foote, Foote, no. Gardner, Gardner, aye. Janal, Janal, no. Gonzalez, Gonzalez, no. Hill, Hill, aye. Heisey, Heisey, aye. Holbert, Holbert, aye. Lee, Lee, no. Lundeen, Lundeen, aye. Marble, Marble, aye. Moreno, Moreno, no. Pedersen, Pedersen, no. Priola, Priola, aye. Rankin, Rankin, aye. Rodriguez, Rodriguez, no. Scott, Scott, aye. Smallwood, Smallwood, aye. Sonnenberg, Sonnenberg, aye. Story, Story, no. Tate, Tate, aye. Todd, Todd, no. Williams, Williams, no. Winter, Winter, no. Woodward, Woodward, aye. Zinzinger, Zinzinger, no. Mr. President,
No.
Mr. President, no.
With 16 ayes, 19 noes, 0 absent, 0 excused, that motion is lost. Senator Gardner.
Thank you, Mr. President. Well, that was disappointing. Apparently, my correction was somehow wide of the mark. So I thought about this as a correction, and I move a correction to that same line to strike it and substitute, Senator Cook requested the bill be read at length, period. The bill was read by a combination of the reading clerk, the calendar clerk, and electronic means with overlapping readings of portions of the bill, at times by 5 separate devices, each reading at the rate of up to 625 words per minute. If the secretary does not accept that as a correction, then I request and make a motion that the journal be corrected as stated.
Is there any further discussion on the amendment? Senator Lundin.
Thank you, Mr. President. I'm pulling up here on my iPhone a recording that I happened to capture of what happened yesterday. And now, it's visible, it's available, you can get it anywhere else that you would like to get it. It's not as if this wasn't a matter of public gibberish, a matter of public record. But the reality is, what we heard yesterday was not in any way, in my mind, intelligible. And I think that's the root of what we're talking about here. Let me see if I can.
Senator Lundin,
Yes, Mr. President.
that is in violation of the rules.
I stand corrected, but please clarify me and help me understand which rule I'm in violation of, Mr. President.
Senator Lundin, you will come to order. You are recognized.
Thank you, Mr. President. So we all heard it. You heard it just now, in whatever context, whether fair and in the bound of the rules or not, but in reality, and you heard it yesterday. I do not know how anyone could argue that that bill was read at length. Now, you could say we read bills at length, and the rules allow for this for a couple of different reasons. One, as Mason says, is so the public can be informed, so that we could be informed, so that we could actually hear what the bill had to say. I think that's valid, that's appropriate, but that's not, in fact, what happened yesterday. The other reason could be, in fact, a procedural, tactical reason. Something was put in the rules a long time ago in defense of the minority. Now, here's the way it plays out in my expectations and my understanding of history and my reading of history. The majority and the minority in our two-party system of government here in the United States and here in the state of Colorado trade roles. One party does not always have the majority status. It is almost as certain as the sun will rise in the morning and set in the evening that the power of the majority will move from party to party. And it is in anticipation of that sunrise and sunset that the rules are created to protect the rights of the minority. And so, whether it's to understand the bill clearly and the public to understand the bill clearly and to know what we're debating and voting upon, or whether it's to protect the rights of the minority, either of those are valid and appropriate. But what happened yesterday, what we heard and tried to discern, was not, in any common sense estimation, a reading of the bill. I urge your support of the motion. Thank you, Mr. President.
The motion before the body is a correction of the amendment. Is there any further discussion? Senator Donovan.
Thank you, Mr. President. I'm going to request a no vote on this amendment. I was actually here the entire time, as opposed to the senator that offered it, and it actually isn't even a correct correction, so I ask for a no vote.
Senator Hill.
Thank you, Mr. President. Point of order. May I ask what rule my fellow senator from Colorado Springs violated at the microphone just now?
The senator from El Paso County is well familiar with the rules in the accordance of the proceedings that govern us. I will not answer that question because he knows that he is in violation. The question before the body is, Senator Hill.
Thank you, Mr. President. I still would like some clarification. I believe I'm under a point of order. I think we as senators are offered a right to know what rules have been violated.
Senator Hill, the senator from El Paso County will recognize that in our rules that govern the Senate, as well as Masons, that electronic devices are not to be used. Senator Hill.
Mr. President, thank you for that clarification. If that's the case, we had electronic devices down here at the microphone for hours yesterday. 2 of them, 1 at each microphone, taped here at the authority of the leadership in the Senate. Mr. President, I don't understand how we can gavel down my fellow senator from Colorado Springs on recording the clear, unintelligible activity in the Senate yesterday, which was created by those same electronic devices that you just said violated the rules. I request a senatorial 5 to clarify.
The question before the body is, Senator Gardner is recognized.
Thank you, Mr. President. Members, I want to be clear why this correction is being offered. The Constitution of the state of Colorado requires, and the presumption is in the Constitution, that all bills will be read in full twice. The Journal states that the bill was read at length at the request of Senator Cook. Now, it is true that Senator Cook requested that the bill be read at length, meaning in full. It is not true that it was read at length. Mason's Manual on Legislative Procedure makes it clear that substantial compliance is required in the reading of a bill in full. What we had yesterday, which was unintelligible, and I won't run the risk of playing my version, I just invite you to go to the General Assembly website and to the record of the proceedings and find the point at which we switch from the reading clerk or the calendar clerk reading this bill in full, quickly at that, but nevertheless intelligibly, to the machine. It is unintelligible. To say in our journal that it was read at length misstates what happened. It is the ultimate dishonesty in my mind to tell the people of Colorado that the Constitution was complied with when it was not. It is also, you say, what's the difference? Well, it matters, because if the Constitution was not complied with, the passage of House Bill 1172 or any other bill that is not read at length upon request or as required, under long-standing Colorado Supreme Court precedent, that bill, if passed, is nevertheless null and void. Mr. President, I submit to you and my colleagues here that the failure to comply with the Constitution in a substantial manner places the proceedings of this chamber and of this General Assembly at risk. To misstate in the journal the historic facts of what happened yesterday place the integrity of this chamber at risk. I ask for an aye vote on this motion to correct the journal, to correctly state what happened in the proceedings of March 11th.
Seeing no further discussion, Senator Lundin.
Thank you very much, Mr. President. So there are several whys in this question. I think the senator from El Paso County just gave us a great legal reason why we want to get this right. I would say there's an even more important common sense reason why we want to get this right. The rules say that the reading at length is for a purpose. I mean, the rules don't just say read at length because, they actually explain why. To prevent hasty and ill-considered legislation, surprise, or fraud, and to inform the legislators. That's kind of important that we know what we're doing. But here's the real reason why. And the public, the contents of the bill. I would challenge any one of us to take a survey of the public, start in the lobby, and then move through the building. Ask those who might have been in the gallery yesterday. Did the public understand what that electronic device was babbling? No, sir. No, ma'am. There is no common sense way you can come to a conclusion that that was reading in whole, at length, or even in part for that matter. There was nothing about it that was intelligible. We need to correct the record to make it clear what actually happened here yesterday. Thank you, Mr. President.
Senator Hill.
Mr. President, I appreciate the chance to address this, and I had requested, I think is also afforded under the rules, a senatorial 5 to discuss it in private off the microphone. Since that was not afforded, I will very clearly highlight what I think is a further point of order. What I know is a further point of order, because Rule 22A, Section B, Paragraph 2 says, this is on page 68 of our rule book, senators, legislative staff, witnesses, and others recognized to speak may use wireless electronic devices to play audio or video recordings while speaking in the Senate chambers, in the hearings of Senate committees, in Senate party caucuses, or in any other official meetings of Senate members held in the Capitol or the Legislative Services Building. What my fellow senator from Colorado Springs was gavelled down for there very clearly is under the rules, which I think is a good thing for the leadership in the Senate right now, because if that was a violation of the rules, then hours and hours and hours yesterday was a violation of the rules. However, it's very clear that that was legitimate under the rules, that it is legitimate under the rules, and Mr. President, I'll just point that out and say I think my colleague was inappropriately gavelled down for highlighting what, look, at the end of the day, you're the head parliamentarian, Mr. President, but I think in order to protect honest, legitimate debate about what has and hasn't happened and what should and should not happen going forward, I believe my fellow senator was inappropriately gavelled down.
The question before the body is the correction amendment 02. All those in favor say aye. All those opposed, no. The noes have it, and the motion is lost. Motion is for the approval of the journal. Senator Danielson. A roll call has been requested on the approval of the journal, the pending motion that was the first. Mr. Carpenter, please poll the senators.
Senators Bridges. Aye. Cook. No. Bridges, aye. Cook, no. Quorum. Quorum, no. Court. Court, aye. Crowder. Crowder, no. Danielson. Danielson, aye. Donovan. Donovan, aye. Finberg. Finberg, aye. Fields. Fields, aye. Foot. Foot, aye. Gardner. Gardner, no. Janal. Janal, aye. Gonzalez. Gonzalez, aye. Hill. Hill, no. Heisey. Heisey, no. Holbert. Holbert, no. Lee. Lee, aye. Lundeen. Lundeen, no. Marble. Marble, no. Moreno. Moreno, aye. Pedersen. Pedersen, aye. Priola. Priola, no. Rankin. Rankin, no. Rodriguez. Rodriguez, aye. Scott. Scott, no. Smallwood. Smallwood, no. Sonnenberg. Sonnenberg, no. Story. Story, aye. Tate. Tate, no. Todd. Todd, aye. Williams. Williams, aye. Winter. Winter, aye. Woodward. Woodward, no. Zinzinger. Zinzinger, aye. Mr. President.
Aye.
Mr. President, aye.
With 19 ayes, 16 noes, 0 absent, that motion is adopted. Committee reports.
March 11, 2019, Committee on Business, Labor, Technology, Advocacy, Research, and American Committee as following. House Bill 1043 be referred to Committee of the Whole. The favorable recommendation. Recommendation to be placed on the consent calendar.
Senate Services.
Correctly printed, Senate Bill 192, 193, and 194. Correctly engrossed, Senate Bill 147, 148, 168. Correctly re-engrossed, Senate Bill 141, 151, 152. Correctly revised, House Bill 1137. Correctly enrolled, Senate Resolution 4.
Message from the House.
The House has passed on third reading and transmitted advisory statutes. House Bill 1065. The House has passed on third reading and transmitted advisory statutes. House Bill 1023, 1186, 1207, 1086, 1026, 1210, 1128. Amendments printed in the House Journal, March 8, 2018. The House has passed on third reading and returns herewith. Senate Bill 103, 1617. The House has passed on third reading and transmitted advisory statutes. House Bill 1197, 1092. Amendments printed in the House Journal, March 11, 2019.
Message from the Reviser.
We herewith transmit without comment House Bill 1065 without comment as amended. House Bill 1023, 1026, 1086, 1128, 1186, 1207, and 1210. We herewith transmit without comment as amended House Bill 1092 and 1197.
Mr. Majority Leader. Third reading of bills, final passage. Mr. Majority Leader.
Thank you, Mr. President. There has been a request to remove Senate Bill 168 and Senate Bill 148, as well as Senate Bill 147 from the consent calendar.
At the request, that will be done. Mr. Majority Leader.
Thank you, Mr. President. I move to lay over third reading of bills final passage consent calendar until Wednesday, March 13th.
You have heard the motion. All those in favor say aye. Aye. All those opposed, no. The ayes have it. And third reading consent calendar will be laid over until Wednesday. Mr. Majority Leader.
Thank you, Mr. President. I move to lay over third reading of bills final passage until Wednesday, March 13th.
You have heard the motion. All those in favor say aye. All those opposed, no. The third reading final bills consent calendar will be laid over until Wednesday, 13th. Mr. Majority Leader.
Thank you, Mr. President. I move to lay over general orders second reading of bills consent calendar until Wednesday, March 13th.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the general orders second reading of bills consent calendar will be laid over until Wednesday, the 13th. General order, second reading of bills. Senator Danielson.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. All those opposed, no. The motion is adopted, and the Senate will resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills, and Senator Danielson will take the chair.
Committee will come to order. Mr. Carpenter, please read the title of Senate Bill 181. Mr. Majority Leader.
Thank you, Madam Chair. I move to proceed out of order for the purposes of taking up Senate Bill 181.
Motion is to proceed out of order to take up Senate Bill 181. All those in favor say aye. All those opposed say no. The ayes have it. Mr. Carpenter, please read the title of Senate Bill 181.
Senate Bill 181 by Senator Finberg and Representative Becker concerning additional public welfare protections regarding the conduct of oil and gas operations.
Mr. Majority Leader.
Thank you, Madam Chair. I move Senate Bill 181 and the Transportation and Energy Committee report, the Finance Committee report, and the Appropriations Committee report.
To the Appropriations Committee report.
Thank you, Madam Chair. In the Appropriations Committee, we discussed the bill. We made an appropriation amendment, and it is all cash funded, no general fund direct impact, and the bill was approved.
Question before us is the adoption of the committee report. Senator Gardner.
Thank you, Madam Chair. I request Senate Bill 181 be read at length.
Senate Bill 181 by Senator Finberg and Representative Becker concerning additional public welfare protections regarding conduct of oil and gas operations. Being enacted by the General Assembly of the State of Colorado, Section 1 in Colorado Revised Statutes 2465.1202, repeal 1D as follows. 2465.1202, criteria for administration of areas of state interest. 1D, strike unless an activity of state interest has been designated or identified, or unless it includes part or all of another area of state interest. An area of oil and gas development shall not be designated as an area of state interest unless the State Oil and Gas Conservation Commission identifies such area for designation. Unstrike. Section 2. In Colorado Revised Statutes 2465.1302, repeal 3 as follows. 2465.1302, functions of other state agencies. 3, strike pursuant to Section 2465.12021D. The Oil and Gas Conservation Commission of the State of Colorado may identify an area of oil and gas development for designation by local government as an area of state interest. Unstrike. Section 3 in Colorado Revised Statutes 257109, add 10 as follows. 257109, Commission to promulgate emissions control regulations. 10A, the Commission shall adopt rules to minimize emissions of methane and other hydrocarbons and nitrogen oxides from the entire oil and gas fuel cycle. B, 1, an oil and gas operator of an oil and gas facility shall install continuous emissions monitoring equipment at the facility to monitor for A, hazardous air pollutants specified by the Commission by rule, B, methane, and C, volatile organic compounds. 2, the Commission may, by rule, phase in the requirement to comply with this subsection 10B on the basis of production capability, type, and age of oil and gas facility, and commercial availability of continuous monitoring equipment. If the Commission phases in the requirement to comply with this subsection 10B, it shall increase the required frequency of inspections at facilities that are subject to the phase-in until the facilities achieve continuous emissions monitoring. C, notwithstanding the grant of authority to the Oil and Gas Conservation Commission in Article 60 of Title 34, including specifically Section 3461.051, the Commission may regulate air pollution from oil and gas operations and oil and gas facilities, including during construction, drilling, and completion activities. Section 4 in Colorado Revised Statutes 292104, amend 1 introductory portion 1G and 1H and add 1I and 2 as follows. 292104, powers of local governments definition. 1, except as expressly provided in Section 292104.5, the power and authority granted by this section, strike shall, unstrike does not limit any power or authority presently exercised or previously granted. Each local government within its respective jurisdiction has the authority to plan for and regulate the use of land by G, regulating the use of land for residential, commercial, recreational, industrial, and other purposes, including mineral resource development, on the basis of the strike thereof, unstrike of the use on the community or surrounding areas, strike and unstrike. H, strike otherwise planning for and regulating the use of land so as to provide planned and orderly use of land and protection of the environment in a manner consistent with constitutional rights. Unstrike, regulating oil and gas operations to address 1. Land use. 2. The minimization of adverse impacts to public health, safety and welfare, the environment, and wildlife. For purposes of this subsection 1H2, minimization of adverse impacts means to A. Avoid adverse impacts from oil and gas operations. And B. Minimize and mitigate the extent and severity of those impacts that cannot be avoided. 3. The location and sitting of oil and gas facilities and oil and gas locations as those terms are defined in Section 3460, 103, 6.2, and 6.4. 4. Impacts to public facilities and services. 5. Water quality and source, noise, vibration, odor, light, dust, air emissions, and air quality, land disturbance, reclamation procedures, cultural resources, emergency preparedness, and coordination with first responders, security, and traffic and transportation impacts. 6. Financial securities, indemnification, and insurance as appropriate to ensure compliance with regulations of the local government. And 7. All other nuisance type effects of oil and gas development. And I, otherwise planning for and regulating the use of land so as to provide planned and orderly use of land and protection of the environment in a manner consistent with constitutional rights. 2. To implement the powers and authority granted in subsection 1H of this section, local governments have the authority to A. Inspect all facilities subject to local government regulation. B. Impose fines for leaks, spills, and emissions. And C. Impose fees on operators or owners to cover the reasonably foreseeable direct and indirect costs of permitting and regulation and the costs of any monitoring and inspection program necessary to address the impacts of development and to enforce local governmental requirements. Section 5. In Colorado Revised Statutes 30-15-401, amend 1 introductory portion, 1M2 introductory portion, and 1M2B as follows. 30-15-401, general regulations definitions 1. In addition to those powers granted by Section 30-11-101 and 30-11-107 and by Parts 1, 2, and 3 of this Article 15, the Board of County Commissioners, strike, has the power to, unstrike, may adopt ordinances for control or licensing of those matters of purely local concern that are described in the following enumerated powers. M2, ordinances enacted to regulate noise on public and private property pursuant to strike subparagraph 1 of this paragraph M shall unstrike subsection 1M1 of this section do not apply to B, property used for manufacturing, industrial, commercial, business purposes, and public utilities regulated pursuant to Title 40, strike CRS, and oil and gas production subject to the provisions of Article 60 of Title 34 CRS, unstrike Section 6 in Colorado Revised Statutes 3460-102, amend 1A introductory portion 1A, 1 and 1B as follows. 3460-102 legislative declaration 1A. It is declared to be in the public interest and the commission is directed to 1. Strike, foster, unstrike, regulate the strike responsible balance, unstrike development, strike production and utilization, unstrike of the natural resources of oil and gas in the state of Colorado in a manner strike consistent with the protection of unstrike that protects public health, safety, and welfare, including protection of the environment and wildlife resources. B. It is strike, not unstrike, neither the intent nor the purpose of this strike article, unstrike Article 60, to require or permit the proration or distribution of the production of oil and gas among the fields and pools of Colorado on the basis of market demand. It is the intent and purpose of this strike article, unstrike Article 60, to permit each oil and gas pool in Colorado to produce up to its maximum efficient rate of production subject to the protection of public health, safety, and welfare, the environment and wildlife resources, and the prevention of waste, strike consistent with the protection of public health, safety, and welfare, including protection of the environment and wildlife resources, unstrike as set forth in Section 3460, 106, 2.5, and 3A, and subject further to the enforcement and protection of the co-equal and correlative rights of the owners and producers of a common source of oil and gas so that each common owner and producer may obtain a just and equitable share of production, strike therefrom, unstrike from the common source. Section 7 of Colorado Revised Statutes 3460-103, amend the introductory portion 5.5, 11, 12, and 13, and add 5.3, 6.2, and 6.4 as follows. 3460-103, definitions as used in this strike article, unstrike Article 60 unless the context otherwise requires. 5.3, local government means except with regard to Section 3460-104-2A1 a municipality or city and county within whose boundaries an oil and gas location is sited or proposed to be.
Excuse me, Mr. Carpenter. Members, the bill's being read at length. Please pay attention to Mr. Carpenter. Please proceed, Mr. Carpenter.
Sited or B county if an oil and gas location is sited or proposed to be sited within the boundaries of the county but is not located within a municipality or city and county. 5.5, minimize adverse impacts means to strike wherever reasonably practicable. Unstrike A, avoid adverse impacts from oil and gas operations. Strike on wildlife resources, unstrike. And B, minimize and mitigate the extent and severity of those impacts that cannot be avoided. Strike C, mitigate the effects of unavoidable remaining impacts. And D, take into consideration cost effectiveness and technical feasibility with regard to actions and decisions taken to minimize adverse impacts to wildlife resources. Unstrike. 6.2, oil and gas facility means equipment or improvements used or installed at an oil and gas location for the exploration, production, withdrawal, treatment, or processing of crude oil, condensate, exploration, and production, waste, or gas. 6.4, oil and gas location means a definable area where an oil and gas operator has distributed or intends to disturb the land surface in order to locate an oil and gas facility. 11, waste as applied to gas. A, includes the escape, blowing, or releasing directly or indirectly into the open air of gas from wells productive of gas only, or gas in an excessive or unreasonable amount from wells producing oil or both oil and gas, and the production of gas in quantities or in such manner as unreasonably reduces reservoir pressure, or subject to subsection 11B of this section, unreasonably diminishes the quantity of oil or gas that ultimately may be produced, excepting gas that is reasonably necessary in the drilling, completing, testing, and in furnishing power for the production of wells. And B, does not include the non-production of gas from a formation if necessary to protect public health, safety, and welfare, the environment, or wildlife resources as determined by the Commission. 12, waste as applied to oil. A, includes underground waste, inefficient, excessive, or improper use or dissipation of reservoir energy, including gas energy and water drive surface waste, open pit storage and waste incident to the production of oil in excess of the producer's above-ground storage facilities and lease and contractual requirements, but excluding storage other than open pit storage reasonably necessary for building up or maintaining crude stocks and products. Strike thereof. Unstrike of crude stocks for consumption, use, and sale. And B, does not include the non-production of oil from formation of, if necessary to protect public health, safety, and welfare, the environment, or wildlife resources as determined by the Commission. 13, waste in addition to the meanings as set forth in subsection 11 and 12 of this section. A means subject to subsection 13B of this section. Strike A, unstrike. 1, physical waste as that term is generally understood in the oil and gas industry. Strike B, unstrike. 2, the locating, spacing, drilling, equipping, operating, or producing of any oil or gas well or wells in a manner, strike which, unstrike that causes or tends to cause reduction in quantity of oil or gas ultimately recoverable from a pool under prudent and proper operations, or strike which, unstrike that causes or tends to cause unnecessary or excessive surface loss or destruction of oil or gas. And strike C, unstrike. 3, abuse of the correlative rights of any owner in a pool due to non-uniform, disproportionate, unrateable, or excessive withdrawals of oil or gas. Strike therefrom, unstrike from the pool, causing reasonably avoidable drainage between tracts of land or resulting in one or more producers or owners. In strike such, unstrike the pool producing more than strike his, unstrike an equitable share of the oil or gas from strike such, unstrike the pool. And B, does not include the non-production of oil or gas from a formation if necessary to protect public health, safety, and welfare, the environment, or wildlife resources as determined by the Commission. Section 8 in Colorado Revised Statutes 3460-104 amend 1, 2A1 and 2A2 as follows. 3460-104 Oil and Gas Conservation Commission Report Publication 1. There is hereby created in the Department of Natural Resources the Oil and Gas Conservation Commission. Strike of the State of Colorado. Unstrike 2A1 effective July 1st. Strike 2007. Unstrike 2019. The Commission Strike shall consist, unstrike consists of 9 members, 7 of whom shall be appointed by the governor with the consent of the Senate. Strike and 2 of whom unstrike the executive director of the Department of Natural Resources and the executive director of the Department of Public Health and Environment. Strike shall be unstrike or the executive director's designees are ex officio voting members. At least 2 members shall be appointed from west of the Continental Divide and to the extent possible. Consistent with this strike paragraph A, unstrike subsection 2A, the other members shall be appointed taking into account the need for geographical representation of strike other unstrike areas of the state with high levels of current or anticipated oil and gas activity or employment. Strike 3 members shall unstrike 1 member must be strike individuals, unstrike an individual with substantial experience in the oil and gas industry. Strike and at least 2 of said 3 members shall have a college degree in petroleum geology or petroleum engineering. Unstrike 1 member strike shall unstrike must be a local government official. 1 member strike shall unstrike must have formal training or substantial experience in environmental strike or wildlife unstrike protection. 1 member strike shall unstrike must have formal training or substantial experience in wildlife protection. 1 member must have formal training or substantial experience in soil conservation or reclamation. Strike and unstrike. 1 member strike shall unstrike must be actively engaged in agricultural production. Strike and also unstrike or be a royalty owner, and 1 member must have formal training or substantial experience in public health, excluding executive directors from consideration. No more than 4 members of the commission strike shall unstrike may be members of the same political party. 2, subject to strike paragraph B of this subsection 2, unstrike subsection 2B of this section. Nothing in this strike paragraph A shall be construed to require unstrike. Subsection 2A requires a holdover member of the commission holding office on July 1st, strike 2007, unstrike 2019, to comply with strike the provision of this paragraph A, unstrike this subsection 2A as amended, unless strike such, unstrike the person is reappointed to the commission for another term of office. Nothing in this strike subparagraph 2 shall alter, impair, or negate. Unstrike subsection 2A alters, impairs, or negates the authority of the governor to remove or appoint members of the commission pursuant to strike paragraph B of this subsection 2, unstrike subsection 2B of this section. Section 9 in Colorado Revised Statutes 346104.5 amend 2D as follows. 346104.5 Director of Commission Duties. 2. The Director of the Commission shall D1 appoint pursuant to Section 13 of Article 12 of the state constitution such clerical and professional staff and consultants as may be necessary for the efficient and effective operation of the commission, including at least 1 and up to 2 deputy directors, and strike shall unstrike 2 exercise general supervisory control over strike said unstrike the staff. In Section 10 in Colorado Revised Statutes 346105 amend 1 as follows. 346105 Powers of Commission. 1A. The Commission has jurisdiction over all persons and property, public and private, necessary to enforce strike the provisions of this article, and has unstrike this Article 60, the power to make and enforce rules, strike regulations, unstrike, and orders pursuant to this strike article, unstrike Article 60, and to do whatever may reasonably be necessary to carry out strike the provisions of this article, unstrike this Article 60. B. Any delegation of authority to any other state officer, board, or commission to administer any other laws of this state relating to the conservation of oil or gas, or either of them, is hereby rescinded and withdrawn, and strike such, unstrike that authority is unqualifiedly conferred upon the commission as provided in this section, except that, as further specified in Section 346131, nothing in this Article 60 alters, impairs, or negates the authority of 1. The Air Quality Control Commission to regulate pursuant to Article 7 of Title 25 the emission of air pollutants from oil and gas operations. 2. The Water Quality Control Commission to regulate pursuant to Article 8 of Title 25 the discharge of water pollutants from oil and gas operations. 3. The State Board of Health to regulate pursuant to Section 2511-104 the disposal of naturally occurring radioactive materials and technologically enhanced naturally occurring radioactive materials from oil and gas operations. For the Solid and Hazardous Waste Commission to A, regulate pursuant to Article 15 of Title 25, the disposal of hazardous waste from oil and gas operations, or B, regulate pursuant to Section 302109 1.5, the disposal of exploration and production waste from oil and gas operations, and 5, a local government to regulate oil and gas operations pursuant to Section 292104C. Any person or the Attorney General on behalf of the state may apply for strike any unstrike A hearing before the Commission, or the Commission may initiate proceedings upon any question relating to the administration of this strike article, unstrike Article 16. Jurisdiction is conferred upon the Commission to hear and determine the strike, same unstrike question, and enter its rule, strike, regulation, unstrike, or order with respect strike thereto, unstrike to the question. Section 11. In Colorado Revised Statutes 346106, amend 1, introductory portion 1F2, introductory portion 2B, 2C, 7, 13, and 15, repeal 2D, and add 2.5, 11C, 18, and 19 as follows. 346106, additional powers of Commission rules, repeal 1. The Commission also has authority to unstrike shall require F1 that no operations for the drilling of a well for oil and gas shall be commenced without first A, strike giving to the Commission notice of intention unstrike applying for a permit to drill, which must include proof either that the operator has filed an application with all affected local governments to approve the siting of the proposed oil and gas location and the local government's disposition of the application, or no affected local government regulates the siting of oil and gas locations, and strike without first unstrike B, obtaining a permit for the Commission under strike such unstrike rule, strike, and regulations as may be unstrike prescribed by the Commission, strike, and unstrike 2, paying to the Commission a filing and service fee to be established by the Commission for the purpose of paying the expense of administering this strike article, unstrike Article 60 as provided in Section 346122, which fee may be transferable or refundable at the option of the Commission. If strike such unstrike the permit is not used, strike, but no such fee shall exceed $200 unstrike, and 3A, notwithstanding any other provision of law, but subject to subsection 1F3B of this section until the Commission has promulgated every rule required to be adopted by legislation enacted in 2019 that amends this Article 60, and each rule specified in this subsection 1F3A has become effective. The Director may refuse to issue a permit if the Director determines that the permit requires additional analysis to ensure the protection of public health, safety, and welfare, or the environment, or require additional local government or other state agency consultation. B, this subsection 1F3 will be repealed if the rules specified in subsection 1F3A of this section have become effective. The Director shall notify the reviser of statutes in writing of the date on which all rules specified in subsection 1F3A of this section have become effective by emailing the notice to reviser of statutes.ga@state.co.us. This subsection 1F3 is repealed effective upon the date identified in the notice that the rules specified in subsection 1F3A of this section have become effective, or if the notice does not specify the date, upon the date of the notice to the reviser of statutes. 2. The Commission strike has the authority to unstrike, may regulate B, the shooting and chemical treatments of wells, and C, the spacing and number of wells allowed in a drilling unit, strike, and unstrike D, strike oil and gas operations so as to prevent and mitigate significant adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations to the extent necessary to protect public health, safety, and welfare, including protection of the environment and wildlife resources, taking into consideration cost effectiveness and technical feasibility. Unstrike 2.5A, in exercising the authority granted by this Article 60, the Commission shall regulate oil and gas operations so as to protect and minimize adverse impacts to public health, safety, and welfare, the environment, and wildlife resources, and shall protect against adverse environmental impacts on any air, water, soil, or biological resource resulting from oil and gas operations. B, the non-production of oil and gas resulting from a conditional approval or denial authorized by this subsection 2.5 does not constitute waste. 7A, the Commission strike has the authority to unstrike, may establish, charge, and collect docket fees for the filing of applications, petitions, protests, responses, and other pleadings. Strike, no such fees shall exceed $200 for any application, petition, or other pleading, initiating, and proceeding nor $100 for any protest or other responsive pleadings, and any party to any commission proceedings shall pay no more than one shed's fee for each proceeding in which it is a party. Unstrike all strikes. Such unstrike fees shall be deposited in the Oil and Gas Conservation and Environmental Response Fund established by Section 346122, and strike shall be unstrike are subject to appropriations by the General Assembly for the purposes of this strike article. Unstrike Article 60B, the Commission shall by rules establish the fees for the filing of applications in amounts sufficient to recover the Commission's reasonably foreseeable direct and indirect costs in conducting the analysis, including the annual review of financial assurance pursuant to subsection 13 of this section, necessary to assure that permitted operations will be conducted in compliance with all applicable requirements of this Article 6011C. The Commission shall adopt rules that, 1, adopt an alternative location analysis process and specify criteria used to identify oil and gas locations and facilities proposed to be located near populated areas that will be subject to alternative location analysis process, and 2, in consultation with the Department of Public Health and Environment, evaluate and address the potential cumulative impacts of oil and gas development. 13, the Commission shall require every operator to provide assurance that it is financially capable of fulfilling strike any, unstrike every obligation imposed strike under subsections 11, 12, and 17 of this section, unstrike by this Article 60 as specified in rules adopted on or after the effective date of this subsection 13 as amended. The rulemaking must consider increasing financial assurance for inactive wells and for wells transferred to a new owner, requiring a financial assurance account which must remain tied to the well in the event of a transfer of ownership to be fully funded in the initial years of operation for each new well to cover future costs, plug, reclaim, and remediate the well. Creating a pooled fund to address orphan wells for which no owner, operator, or responsible party is capable of covering the costs of plugging, reclamation, and remediation for purposes of this subsection 13. References to operator strike shall unstrike include an operator of an underground natural gas storage cavern and an applicant for a certificate of closure under subsection 17 of this section. In complying with this requirement, an operator may submit for commission approval without limitation one or more of the following: A guarantee of performance where the operator can demonstrate to the commission's satisfaction that it has sufficient net worth to guarantee performance of strike any, unstrike every obligation imposed by strike rule under subsections 11, 12, and 17 of this section. Such unstrike this Article 60. The Commission shall annually review the guarantee and demonstration of net worth. Strike shall be annually reviewed by the Commission. Unstrike B, a certificate of general liability insurance is a form acceptable to the Commission. Strike which unstrike that names the state as an additional insured, and strike which unstrike covers occurrences during the policy period of a nature relevant to an obligation imposed by strike rule under subsections 11, 12, and 17 of this section. Unstrike this Article 60C, a bond or other surety instrument. D, a letter of credit, certificate, or deposit, or other financial instrument. E, an escrow account or sinking fund dedicated to the performance of strike any, unstrike every obligation imposed by strike rule under subsections 11, 12, and 17 of this section. Unstrike this Article 60F, a lien or other security interest in real or personal property of the operator. Strike such unstrike the lien or security interest. Strike shall unstrike must be in a form and priority acceptable to the Commission in its sole discretion. Strike and shall be reviewed annually by unstrike. The Commission shall annually review the lien or security. 15, the Commission may, as it deems appropriate, assign its inspection and monitoring function, but not its enforcement authority through intergovernmental agreement or by private contract, except that strike no such unstrike an assignment. Strike shall unstrike must not allow for the imposition of any new tax or fee by the assignee in order to conduct strike such unstrike the assigned inspection and monitoring, and strike no such assignment shall unstrike must not provide for compensation contingent on the number of nature of alleged violations referred to the Commission by the assignee. Strike no local government may charge a tax or fee to conduct inspections or monitoring of oil and gas operations with regard to matters that are subject to rule, regulation, order, or permit condition administered by the Commission. Nothing in this subsection 15 shall affect the ability of a local government to charge a reasonable and non-discriminatory fee for inspection and monitoring for road damage and compliance with local fire codes, land use permit conditions, and local building codes. Unstrike. 18, the Commission shall promulgate rules to ensure proper wellhead integrity of oil and gas production wells. The rules must address the use of non-destructive testing of weld joints and require the certification of oil and gas field welders. 19. The Commission shall review and, if necessary, amend its flow line and inactive, temporarily abandoned and shut-in well rules to ensure that the rules protect and minimize adverse impacts to public health, safety, and welfare and the environment, including by A, allowing public disclosure of flow line information and evaluating and determining when a deactivated flow line must be inspected before being reactivated, and B, evaluating and determining when inactive, temporarily abandoned, and shut-in wells must be inspected before being put into production or used for injection. Section 12 in Colorado Revised Statutes 3460-116. Amend 1367A, 27A3, 7C, and 7D1 and add 7A4 as follows. 3460-116 drilling units, pooling interests. 1A, to prevent or to assist in preventing waste, to avoid the drilling of unnecessary wells, or to protect correlative rights to the Commission upon its own motion or on a proper application of an interested party, but after notice and hearing, as provided in this section, may establish one or more drilling units of specified size and shape covering any pool or portion of a pool. B, the application must include proof that either 1, the applicant has filed an application with all affected local governments to approve the siting of the proposed oil and gas location in the local government's disposition of the application, or 2, no affected local government regulates the siting of oil and gas locations. 3, the order establishing a drilling unit, A, is subject to section 3460-106 and B, may authorize one or more wells to be drilled and produced from the common source of supply on a drilling unit. 6A, when 2 or more separately owned tracts are embraced within a drilling unit, or when there are separately owned interests in all or part of the drilling unit, then persons owning strike such unstrike the interests may pool their interests for the development and operation of the drilling unit. B1, in the absence of voluntary pooling, the Commission, upon the application of strike any interested person, unstrike a person who owns or has secured the consent of the owners of more than 50% of the mineral interests to be pooled, may enter an order pooling all interests in the drilling unit for the development and operation thereof, strike each such unstrike of the drilling unit. 2, the pooling order shall be made after notice and a hearing, and strike shall unstrike must be upon terms and conditions that are just and reasonable, and that afford the owner of each tract or interest in the drilling unit the opportunity to recover or receive without unnecessary expense strike his unstrike a just and equitable share. C, operations incident to the drilling of a well upon any portion of a unit covered by a pooling order shall be deemed for all purposes to be the conduct of such unstrike operations upon each separately owned tract in the unit by the several owners strike thereof, unstrike of each separately owned tract, that portion of the production allocated or applicable to each tract included in a unit covered by a pooling order shall, when produced, be deemed for all purposes to have been produced from strike such unstrike the tract by a well-drilled strike thereon, unstrike on it. 7A, each pooling order must, 2, determine the interest of each owner in the unit and provide that each consenting owner is entitled to receive, subject to royalty or similar obligations, the share of the production from the wells applicable to the owner's interests in the wells, and unless the owner has agreed otherwise, a proportionate part of the non-consenting owner's share of the production until costs are recovered, and that each non-consenting owner is entitled to own and to receive the share of the production applicable to the owner's interest in the unit after the consenting owners have recovered the non-consenting owner's share of the costs out of production. Strike and unstrike. 3, specify that a non-consenting owner is immune from liability for costs arising from spills, releases, damage, or injury resulting from oil and gas operations on the drilling unit. And 4, prohibit the operator from using the surface owned by a non-consenting owner without permission from the non-consenting owner. C, a non-consenting owner of a tract in a drilling unit that is not subject to any lease or other contract. 4, strike the development thereof for unstrike oil and gas development shall be deemed to have a landowner's proportionate royalty of strike 12 1/2, unstrike 15% until strike such time as unstrike the consenting owners recover only out of the non-consenting owner's proportionate strike 7/8, unstrike 85% share of production. The costs specified in subsection 7B of this section. After recovery of the cost, the non-consenting owner then owns his or her full proportionate share of the wells. surface facilities and production, and then is liable for further costs as if the non-consenting owner had originally agreed to the drilling of the wells. D1, the commission shall not enter an order pooling an unleased non-consenting mineral owner. Strike shall not be entered by the commission on strike under subsection 6 of this section over protest of the owner unless the commission has received evidence that the unleased mineral owner has been tendered no less than 60 days before the hearing a reasonable offer made in good faith to lease upon terms no less favorable than those currently prevailing in the area at the time application for the order is made, and that strike such unstrike the unleased mineral owner has been furnished in writing the owner's share of the estimated drilling and completion cost of the wells, the location and objective depth of the wells, and the estimated spud date for the wells or range of time within which spudding is to occur. The offer must include a copy of or link to a brochure supplied by the commission that clearly and concisely describes the pooling procedures specified in this section and the mineral owner's options pursuant to those procedures. Section 13 in Colorado Revised Statutes 346122 amend 1B as follows. 346122 expenses fund created 1B on and after July 1, strike 2014, unstrike 2019. The commission shall ensure that the strike 2-year average of the unstrike unobligated portion of the fund does not exceed strike $6 million, unstrike 50% of total appropriations from the fund for the upcoming fiscal year, and that there is an adequate balance in the strike environmental response account created pursuant to subsection 5 of this section unstrike fund to support the operations of the commission and to address environmental response needs. Section 14 in Colorado Revised Statutes 346128 repeal 4 as follows. 346128 Habitat Stewardship Rules 4 strike nothing in this section shall establish, alter, impair, or negate the authority of local and county governments to regulate land use related to oil and gas operations. Unstrike Section 15 in Colorado Revised Statutes at 346131 as follows. 346131 no land use preemption most protective standard controls 1A nothing in this Article 60 impairs or negates the authority of the local government to regulate land use and the sitting of oil and gas locations and facilities. B an operator is subject to local government's land use and siting authority as provided by law and shall ensure that the location of oil and gas locations and facilities complies with local government land use and siting regulations. 2 local governments and state agencies including the commission and agencies listed in Section 346105(1)B have regulatory authority over oil and gas development, including as specified in Section 346105(1)B. If there is a conflict between the regulations or standards of a local government and a state agency, including the commission, or between state agencies regarding an exercise of authority, the regulation or standard that is rationally designed to be more protective of public health, safety, and welfare, the environment, or wildlife resources control. Section 16 applicability. This act applies to conduct occurring on or after the effective date of this act, including determinations of applications pending on the effective date. Section 17 safety clause. The General Assembly hereby finds, determines, and declares this act is necessary for the immediate preservation of the public peace, health, and safety.
To the Transportation Committee report.
Thank you, Madam Chair. In the Transportation Energy Committee, we had a long discussion. In fact, we debated this bill for, I think, close to 12 hours. It was a good debate. It was a good discussion. We amended the bill to clarify some pieces that were clearly confusing folks and were potentially, at times, had fears that it could result in unintended consequences. We fixed some of those things as well as some technical aspects. Happy to talk about it more throughout the debate today. But I move the Transportation Energy Committee report.
The question before us is the adoption of the Transportation Committee report. All those in favor say aye. Aye. All those opposed say no. The ayes have it. The committee report is adopted. To the Finance report.
Thank you, Madam Chair. In the Finance Committee, we also had a long conversation and debate about this bill. I think it was productive. We amended the bill with, I believe, 3 different amendments. that clarified some technical pieces, but also stated that the director of the Colorado Oil and Gas Conservation Commission within, I believe it was a year or maybe it was a year and a half, would submit a report to the General Assembly on structural changes to the commission, including the potential to professionalize the commission, just like the Public Utilities Commission currently is, as well as to empower hearing officers and other staff to have some of the mineral disputes that happen every day at the commission to fall into the purview of staff instead of the commissioners all the time. And happy to chat more about some of the changes that were made throughout the debate today. I move the Finance Committee report.
Question before us is the adoption of the Finance Committee report. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. The committee report is adopted. To the Appropriations Committee report.
Thank you, Madam Chair. We also had another long debate and discussion in the Appropriations Committee on this bill and discussed the financial aspects of the bill, made an appropriations clause, but the appropriations and the impacts were generally just for cash funds, as you'll see in the fiscal note. I move the committee report.
Thank you. The motion before us is the adoption of the Appropriations Committee report. All those in favor say aye. All those opposed say no. The ayes have it. The committee report is adopted. To the bill.
Thank you, Madam Chair. Members, now that we've read this bill at length, maybe we don't need to discuss it. Maybe we totally understand what it does. I assume everybody was paying close attention, just as you were, to the Title 12 recodification bill brought by some of our colleagues yesterday. But with the assumption that perhaps some people missed a few pieces of the bill that was read just now, I want to clarify what it does. And perhaps more importantly, I want to clarify what it does not do. Senate Bill 181 is about one thing, and that is to ensure that we are protecting the health and safety of Coloradans. This bill does that by addressing a few areas of statute. First and foremost, it does it by saying that the regulator for the oil and gas industry in Colorado will now be a regulator rather than an entity that fosters the industry. The job of a regulator, in my opinion, is to regulate. That's what this commission will do if this bill passes. In order to meet the new mission of regulating and doing so with an eye towards protecting health and safety, there will be some changes at the commission level. Not wholesale changes, but some changes to the expertise that is on the commission to adequately fulfill that mission. However, I do think, as we've seen over the recent years, that some of these conflicts when it comes to oil and gas in communities probably can't be solved at the state level alone. But local communities probably need to have a little bit more authority. They should be empowered to decide their fate, to decide their destiny as a community, to have that discussion at a local level, just like they do on virtually every other area of land use regulation. So, as we've heard about in the press and we've discussed at length in committee hearings last week, this bill provides permissive, optional authority for local governments to regulate siting and land use as it comes to oil and gas extraction activities in their community. It provides, again, that permissive, optional authority. I and many others believe that there will be a handful of communities that probably fully take this authority. They will be the ones that have the expertise, they will be the ones that have the interest and the requests of their citizens to be a little bit more involved in the siting and regulation of oil and gas within their boundaries. The bill also modernizes what is called forced pooling. Currently, Colorado has probably the least stringent forced pooling law in the country. 10 states or so don't allow forced pooling whatsoever. They do not allow what is essentially eminent domain for a private industry at all. The states that do allow some level of forced pooling, which for those who are not familiar with this practice, essentially is saying that an operator can force mineral owners to sell or lease their property to the operator against their will. That is in statute, and it has been for a very long time. Most states that have a forced pooling law require some sort of threshold of that mineral pool to agree to extract those minerals, to agree to sell them before the rest of the interest owners are forced to sell their property. We do not have that threshold. Our threshold is that one person can force everybody within that pool to sell against their will. I don't think that's right. I don't think that's in the spirit of our country or of the state of Colorado and what we stand for. And so this bill increases the threshold from one person that could own 0.001% of the mineral interests and raises it to a simple majority. So within a pool, this would require half of the people to consent to selling or leasing their minerals for extraction before the operator can then still force the other half to sell against their will. I still think it's relatively egregious if you take a step back and think about what this law provides. I think this makes it a little bit more right, and I think it's a reasonable thing to do. The bill also addresses orphan wells, both for cleaning up existing wells that are scattered around our state and are right now, today, threatening the health and safety of people and our environment. And it also says that the commission will do a rulemaking to ensure that future wells have the appropriate financial assurances attached to them so the operators are on the hook to clean up whatever mess they may create. So they cannot just walk away from a well, abandon it, without appropriately plugging and making sure that the risks are mitigated. The bill also addresses emissions from oil and gas operations as well as air quality. It requires the Air Quality Control Commission, where they have the expertise for this type of rulemaking, to do rulemaking that would reduce harmful emissions. A few days ago, I was driving into Denver, and I could barely see out my window. Our air quality was 3 or 4 times worse than Beijing. Think about that for a second. Colorado's air quality was 3 or 4 times worse than Beijing. I don't think John Denver would be happy about that. That's not the Colorado we know. That's not the Colorado we love. It's frankly kind of embarrassing, and it's scary. 30 to 40% of our emissions are said to be from oil and gas industry. It doesn't mean the industry should go away. It doesn't mean the industry should be shut down. It doesn't mean there should be a moratorium. It doesn't mean there should be a ban. It means we should have sensible rules on the books that take control of the level of emissions that are coming from this industry for our own air quality and health aspects. That's essentially what this bill does. Now, I want to spend a few minutes to talk about what this bill does not do, although I'm sure we will continue to talk about these things that the bill does not do throughout the day. This bill does not allow de facto bans. No matter what the TV screen says, no matter what editorials you read say, this does not allow a ban at the local level or at the state level. The bill is, in my opinion, pretty clear that any regulation has to be rational, it has to be reasonable, it has to be for the purposes of minimizing negative impacts on health and safety. If something is being unreasonable, if a city or a county is doing something that doesn't seem rational or doesn't actually improve health and safety standards or protections, I imagine, this is a crazy idea, the oil and gas industry will go to court, just like they currently do all the time when it comes to disputes with property owners, with local governments, or even sometimes the commission itself. That is how our laws are written. And if someone abuses the law and does something that is not provided in the law, people go to court. And I believe the industry has the resources at times to do it. I also believe, though, that local governments are not going to generally do anything that is unreasonable. Most local governments aren't going to take the authority that this bill will give them. It will be optional. And the ones that do it, I think, will be incredibly careful to make sure their regulations are written in a way that are defensible. This bill is also not Proposition 112. We've also heard that. This is Proposition 112, and everybody just overwhelmingly said, we don't want Proposition 112. Yeah, voters said they did not want to put Proposition 112 in the law. They did not say we no longer need to have a conversation about any oil and gas regulations. They did not say, therefore, we don't care about the health and safety of Coloradans that are scared right now. We're fearful of what's going to come down in the future in their community. That's not what the failure of 112 was about. 112 was about a one-size-fits-all approach to setbacks across the state. This bill does not mention setbacks whatsoever, does not create setbacks. It is not about what Proposition 112 was. This, in many ways, is the antithesis of Proposition 112. This allows for local governments to have a nuanced discussion among their community about what regulations are right for their community. That is not what Proposition 112 was. I believe this is essentially the opposite of what Proposition 112 was trying to do when it comes to regulating oil and gas. This bill also is not a moratorium. There's a section of the bill that says before these new regulations are promulgated and are in effect, the Colorado Oil and Gas Conservation Commission director has discretion to not approve certain permits that provide a health and safety risk or need additional consultation with the local government. The industry themselves have sat down in my office and said, we know this isn't a moratorium, but the TV ads they're running, the talking points they send you, say this is a moratorium. They know this is not a moratorium, it is instead a talking point. I am open to clarifying that piece of the bill, to say that what we are after here are making sure that in the meantime, which could take a year or so before these rules are adopted, we shouldn't be allowing permits to be approved that in a few months wouldn't have been approved because they pose a health and safety risk. This bill's intention is to provide health and safety protections for Coloradans today, not 10 years from now. And with the pending backlog of permits that are at the commission right now, it would be about 10 years before a new permit would be decided under the new rules, because that is how many permits are pending and how long it will take potentially to get through those pending permits. This bill is also not a job killer or something that will devastate the economy. The reality is if our intention with this bill was to destroy the oil and gas industry, I could have written that bill in less than a page. This has almost 30 pages because the intention here is to create a regulatory framework to have certainty for not only the oil and gas industry, but for communities that are impacted by it. I think we can all agree that there is no certainty right now, whether there's going to be another ballot measure, another piece of legislation, another very unfortunate event that will result in additional rules or legislation. I think it is in everyone's interest to create certainty, and that's what every single line on these 30 or so pages attempts to do. Now, I want to say just a couple of words about process, because we've heard that word quite a bit. Several of you have talked about the process in your emails to constituents, in your press releases, here at the well. The argument is that there was no stakeholder process. The argument is that we were told about a stakeholder process at a press conference, but it turns out they were lying. We were not lying. If I was lying, I wouldn't have wasted those 3 months of my life in a stakeholder process. I wouldn't have had the 92 meetings that we had with the stakeholders. I counted them, 92 meetings. If you count the ones from yesterday, maybe 105. That includes stakeholders from the industry, local governments, elected officials, environmental organizations, attorneys, experts at the Air Quality Control Commission, at the Colorado Oil and Gas Conservation Commission, at DNR. But I do want to be clear that none of those groups or those individuals wrote this bill. The sponsors wrote this bill. That is how legislation is written. Sometimes sponsors will include others in the crafting of language and give them permission to work with the drafter. I did not do that, but that, to me, was not appropriate for this bill of this magnitude on both sides of the issue. Special interests, advocates, activists, they don't write bills, we do, and then we debate them. And we have had a robust debate. Over the last week, this bill has gotten more committee hearings than it needed to, and I think it's probably received more debate and attention than any other bill so far this legislative session. To say that there was a problem with process is a red herring. Everybody knew this bill was coming. Everybody knew what the bill was going to attempt to do. We said it not only at a press conference, we said it to the press, and there were articles. I think the titles of the headlines were, "Oil and Gas Bill is Imminent." And then we did a press conference, and we said, in the coming days, this bill will be introduced. And then in the coming days, oh my God, we introduced a bill. Maybe we should have seen that one coming. We all did. And the bill has gone through its appropriate process, and we are here today to do what I hope is debate the merits of the policy. To not obstruct, and hopefully not to spread misinformation about what this bill doesn't do or does do, but instead to have a conversation about what is the regulatory framework we need to have in the state of Colorado to ensure an oil and gas industry can thrive, but not at the risk of hurting people. That is what this bill is about. Everything in this bill in many ways is negotiable. That's what we do here. We negotiate, we compromise, we find solutions to complex problems. The thing that is not negotiable for me is making sure that this bill protects health and safety of Coloradans. That's where I will stand my ground. And I look forward to the debate that we'll continue to have today.
Is there further discussion on Senate Bill 181? Senator Crowder.
Thank you, Madam Chair. I thought I would come up and speak on this. The best way to do this is let you know what other people are saying. This is in the Pueblo Chieftain in today's paper. Legislation is on a lightning fast track at the Capitol, crafted with no input from workers and industries affected. Would drastically change Colorado's operating rules for the state's energy industry. At EVRAZ, Rocky Mountain Steel.
Senator Crowder.
Madam?
I'm sorry to interrupt. Are you referencing an article that references Senate Bill 181?
Yes, I am.
Okay, because you didn't say that on the front end, and we're going to be real careful about keeping things to this bill and not a broader issue. Please continue.
Madam Chair, this is directly related to this bill.
Please continue.
At EVRAZ, Rocky Mountain Steel, we are gravely concerned about the economic damage this legislation would cause in the Pueblo area and across the state. Why is the steel mill so concerned about oil and gas legislation? EVRAZ, Rocky Mountain Steel, is the largest private employer in Pueblo and a leading steel manufacturer in North America. As a leading producer of pipe used in oil and gas production in Colorado, policies impacting the energy industry have a direct and profound impact on our business. This is true of many companies throughout Colorado that devote all or part of their business to providing goods and services to Colorado energy industry. In the case of EVRAZ Pueblo Steel Mill, which has been a pillar of the region's economy for nearly 140 years, the provision of Senate Bill 181, including its ill-considered moratorium on new permits while additional regulations are put in place, would be damaging to our mill and our workforce. When the energy industry slows down, it engages in less exploration. Less exploration means it needs less pipe. It is very straightforward progression. This threat would be difficult enough to swallow if it had emerged from the robust and transparent dialogue among the many stakeholders in the oil and gas debate. Conversion and smart compromise have been the hallmark of Colorado's work to strengthen energy and regulations, with the result that our state already has the nation's strictest rules. Sadly, the current process is the exact opposite and thorough and inclusive processes we have seen in the past. The current bill is being rammed through the legislature in a way that longtime Capitol observers say is virtually unprecedented for such a sweeping bill. This process is creating the impression that advocates don't want to hear and consider concerns from those who have contrary points of view. That is a recipe for bad legislation. We are hopeful that our Pueblo delegation in the State House and Senate, who have been such strong supporters of the mill and our workers, will help pump the brakes, slow this bill down, and insist on an open and inclusive dialogue. Nothing good comes from creating a rush law or regulation that lacks the voices and input of those who would be the most affected, including local communities, employers, and workers. Continuing the current path is perilous. In addition to the over-threats we know are in the bill, we are equally concerned about unintended consequences, which we believe can be prevented through listening to the views of experts, including those who understand the science involved in energy exploration. Rushing to the finish line without considering the true cost of Senate Bill 181 will result in economic damage in the Pueblo region and across the state that cannot be easily or quickly reversed. It's vital to get this legislation right, and we urge lawmakers to do the right thing for Pueblo, for working for families, for public safety, and for state's critically important energy industry. This is written by Ben Lutz, Vice President and General Manager of EVRAZ, Rocky Mountain Steel. I think that this just, what I get out of this actually displays that there's more to the state of Colorado than Boulder and Denver, and I think what we ought to do is look at how this does impact rural Colorado. You know, we've talked about basically the jobs within the energy industry, but very little have we talked about the supporters of that industry that come from the private sector. So I just want EVRAZ to know that I will stand for Pueblo and Southern Colorado and be a no vote on this bill. Thank you.
Mr. Majority Leader.
Thank you, Madam Chair. I think I probably spent enough time on it in the, I don't know how many minutes I discussed this bill just moments ago. But to state that there was no stakeholder process, that there was no input, is false. I really hope we can talk about the policy that is in this bill, not about spreading falsehoods or denigrating other communities within our state. I hope we can talk about the process, or sorry, about the policy and the process that we are now involved in. Because this is a normal part of the process of passing legislation. This is what we do every day. This bill has gone through every step that it needed to go through. In fact, it went through additional ones. This bill has gotten more debate, more discussion, more input. I would argue almost more stakeholdering than any other bill this session. 90+ meetings. If that's not a stakeholder process, then I would like 3 months of my life back. Again, this is also not a moratorium, and I think I explained that, and we discussed that for almost 20 hours in committees. There's a section in this bill that says some permits that currently pose a health and safety risk are allowed to be slowed down for additional research. Doesn't say shall not be approved. Says the director shall do additional research to see if they actually do pose a health and safety risk. I would hope nobody in this chamber is arguing that if a professional that regulates this industry thinks there is a pending permit that poses a real health and safety risk, that we should rubber stamp that. I would hope that's not what we are advocating for, but instead would advocate for smart regulation and smart approaches to what we allow to be in residential neighborhoods next to families.
Senator Foote.
Thank you, Madam Chair. I'm sure that I'll have a few things to say about this bill as time goes on, but since we heard just earlier the recitation of a letter, it brought to mind a letter that I received just before the Senate Transportation and Energy Committee, and I don't want to read the whole letter, but what I do want to do is point out a couple of things that I think are very pertinent to this debate. This person that wrote me the letter is someone actually that I had worked with in another job for about 10 years, so I know her quite well. She wrote in part about Senate Bill 181, Dear Senate Transportation and Energy Committee members, our neighborhood in Erie is next to a fracking site. Like many people, we were ignorant with respect to the actual fracking impact it would have on our life. The experience was horrible. She went on to say, after we moved to Erie for 9 months, the fracking site at 10.5 and Weld County Road 1 roared around the clock. The noise coming from that site and others nearby was like a helicopter or a train engine. Outside of our windows, almost ceaselessly, from September to May, we rarely slept an entire night, even with earplugs. The initial air emissions were shocking. We wore charcoal masks inside and purchased multiple air cleaners for our home. We could never open our windows or doors. Skipping down to the letter, she mentioned the worst event that we experienced was Christmas morning, 2016. A cloud of noxious fumes so thick one could not even breathe. Complaints filed with the COGCC were responded to in an unsatisfactory and perfunctory manner. It is inconceivable that a dangerous industrial complex is left to police itself. We were told by the COGCC that there are no rules for exhaust emissions because it is a, quote, temporary situation. 9 months of temporary, with emissions ongoing and more fracking sites going in. The last part I'll highlight in this letter says, oil and gas companies put a United States flag on top of most of their drilling rigs. Our nation should be about the health and safety of its citizens first and foremost, not the wealth of its oil companies. The benefits to the community from these sites are small compared to the adverse and ongoing impact to ourselves, our land, and our air. This bill is critically imperative. Finally, she says, people who do not live next to these horrific sites have no idea, just as we did not. And this is relevant for many reasons, of course, but also because this is what people have been saying for the last 10 years to no effect. They've made complaints to the COGCC, to the CDPHE, to their local governments. They go to their local governments, and the local governments say, I'm sorry, my hands are tied, because if we try to do anything, then we'll get sued, which is true. So they go to the state, and the folks at the state will listen politely and then just not do what's asked, because their job has been to foster the industry, not to protect health and safety. Fostering the industry always came first under the mission statement. For 10 years, people like this have been trying to come forward. They have come forward to be listened to, and they have not been listened to. Nothing has happened. Not a thing has happened to protect these folks, and that's why Senate Bill 181 is so imperative. Now, there have been plenty of falsehoods that have gone around about this bill, but the bottom line about this bill is it protects health and safety. That's what it does. It puts that first. People like this woman that wrote me the letter and the committee the letter, and countless others that have lived next to these sites, I'm sure would have wished that this bill would have been in place. So health and safety could be first, not fostering the industry. The industry does a good enough job of that itself. Please support this bill.
Senator Lundin.
Thank you, Madam Chair. I'm going to confine my comments at this juncture to comments around process.
Senator Lundin, I'm going to interrupt right there. I just want to remind the body that it is a privilege to be recognized by the chair, as you know, and I'm going to insist on courteous and respectful debate about the bill topic, the bill itself, and will keep us to that debate throughout the morning. Please proceed, Senator Lundin.
Thank you very much, Madam Chair, and I do intend to speak to this bill, its development, its drafting, its potential, I would assume, amendment, the various aspects of this bill, the reality of what it means to us as Coloradans, et cetera. So yes, Madam Chair, I will confine my comments to the debate with regard to this bill. I had a question for the bill sponsor, but I'll go ahead and offer it up because it may be, in fact, a metaphor for what's happened here. The question is not quantity of stakeholding. We heard some comments that there were 92 stakeholder meetings. In fact, possibly yesterday there were 13 more. I did the math. 92 prior to yesterday, and maybe during the course of yesterday we ran up to 105, so 13 additional stakeholder meetings yesterday. The question becomes one of quality. What was the quality of those stakeholder meetings? And I was thinking it might be a little bit of an echo, a metaphor, that I'm asking that question to not have it heard, because I think that's part of why there is a sense and a cry and an argument that there really hasn't been any stakeholding, because the people who come to the table, who have expertise, who have engagement, who have, in fact, being an effect or a potential effect on their lives, their livelihood, their health, their safety, et cetera, by this bill, don't necessarily feel that they have, in fact, been heard. To the idea that we have had a robust and well-developed process, I would simply turn to the comments of the Denver Post, not someone that I would typically find myself perfectly in alignment with from their editorial perspective, and acknowledge the opinion piece that they released just recently that said, frankly, we're surprised the 7 members of the Senate Transportation and Energy Committee felt they had enough good understanding of this legislation to vote on it. They continue on to say, we urge them to pump the brakes, that's the bill's sponsors in the Democrat Party, on this particular piece of very complex legislation that has implications for the health of our public and our economy. I had the good fortune to have some of my questions asked and answered in the Finance Committee as we heard this for a few hours the other day in Senate Finance, but not all of them. But the lingering question that we all need to pay attention to is the potential economic impact that affects all of us, and it affects us at the core of our being. The Post editorial goes on to say something that I think is quite telling. It says, the last thing Democrat lawmakers should want is the appearance that they have become rubber stamps for an agenda set by the party instead of critical voters sifting through policy for the good of their constituents. And then, as if to put an exclamation point on that, the guest opinion piece offered up just below that in last Friday's Denver Post is offered by Ken Salazar, a proud Democrat he calls himself. He served the state and nation as the Attorney General of the state, a United States Senator, and Secretary of the Department of Interior. And here is his summary comment on this particular piece of legislation. Senate Bill 181 concerning oil and gas operations is too extreme for Colorado and harmful to Colorado's workers, schools, and businesses. The bill should be opposed as introduced. So as I said, I'll confine my comments to the process, the accelerated pace through which this particular piece of legislation is moving through the process. I do have more comments and questions regarding the effect on the economy, but right now I would leave at this podium a question about the quality of the stakeholding, and I don't usually comfortably use that word, I think it's important that we consider all individuals. We don't confine them into boxes and then call them stakeholders, but the people and their representatives, as they've tried to engage on this, what was the quality of that process like? And Madam Chair, thank you for acknowledging me.
Thank you, Senator Lundin. I think I need to remind the body again, when I say that we need to keep to the topic, we need to remain on the relevance, the subject matter of the bill or the amendment at hand. So please do so going forward. The subject matter of the bill, according to Mason's and the Colorado State Senate rules. Thank you very much. Please proceed, Mr. Majority Leader.
Thank you, Madam Chair. I'm not going to rebut everything that is said at this well today, but the Transportation and Energy Committee was 7 days ago. 7 days is a pretty good amount of time in the course of a 120-day session. Within those 7 days, the exact group that we were just being quoted from wrote another editorial and says there is much to like about Senate Bill 181. Now let's perfect it and get it into law. I came here to work today to perfect it. I hope all of us did. Let's perfect it and get it into law.
Senator Cook.
Thank you, Madam Chair. A couple things regarding this bill and the process, as you mentioned. The sponsor of this bill brought up the process, and I think as the minority party, we have a right to respond to what he brought up. I find it kind of disturbing and troubling that the majority is trying to stifle the voice of the minority in this debate. And process is important because that's how we got here. You know, just because somebody says something over and over and over again doesn't make it true. And unfortunately, when people say things over and over and over again, other people think that it's true. Senate Bill 181 is an absolute tragedy and a failure of leadership. And you know what? It's personal. It's very personal to me because this chamber is about to economically destroy my county. You know what most people don't see is that while we may disagree on policy, many of us are friends, which is why this is so painful. I cannot believe that there are people in this chamber who are my friends and will vote economic destruction on my district, my county, and my home. First, let's be clear of what this bill is. It's an attack on an entire community that develops products we all use, an entire community that is more than a $30 billion to our economy in Colorado, an entire community that employs hundreds of thousands of Coloradoans, an entire community that contributes hundreds of millions of dollars to our general fund. This bill seeks to destroy an entire community that provides much needed dollars for everything from equipment for first responders to brand new rural schools. An entire community that includes people like Megan from New Raymer, the volunteer firefighter, and Raul, the migrant worker turned welder who works for oil and gas. This bill seeks to destroy an entire community that includes my own son, who's proud to be a petroleum engineer. Sponsor says this bill is about local control, but that's not true. It's actually about
Senator Cook, I'm sorry to interrupt. You can't call out members that haven't been recognized by the chair, and you cannot impugn someone's motives. You just said that the sponsor's statements were untrue. So please, again, refrain from calling out members, refrain from impugning our motives, and please keep your debate to the bill, and we will respect what you have to say. Senator Cook.
Madam Chair, I did not impugn anybody's integrity down here or motives. I said there are some people. Now, I can't help what other people think when I say that, but thank you. Anyway, this is about boulder control. It's no secret that some in Boulder want to ban the entire extraction industry. Let me read the part of the bill. Notwithstanding any other provision of law, but subject to subsection 1F3B of this section, until the Commission has promulgated every rule required to be adopted by Senate Bill 19-181, enacted in 2019, that amends this Article 60, and each rule specified in this subsection 1F3A has become effective, The director may refuse to issue a permit if the director determines that the permit requires additional analysis to ensure the protection of public health, safety, and welfare of the environment, or requires additional local government or other state agencies' consultation. This kind of delay is tantamount to a ban. Energy developers will take their equipment and their jobs and go to other areas. Weld County will be devastated, make no mistake about it. This is legislatively induced recession. It's economic class warfare, and it's economic racism. Don't believe me? Just look at Calgary. Calgary paper reported on June 24th, 1918, the oil and gas recession in Alberta left thousands of Canadians without jobs. Then, when the rules are finalized and Weld County can produce again, when the Boulder-centric state rules conflict with the Weld County is doing, on page 30, if there's a conflict between the regulation or standards of local government and a state agency, including the commission, or between state agencies regarding an exercise of authority, the regulation or standard that is rationally designed to be more protective of public health, safety, and welfare, the environment or wildlife resources controls. That's not local control. We'll hear, oh, local control, this is all about local control. It's not. You either opt in or opt out. If you opt in, you have to follow the state rules. If you don't want to opt in, you can opt out. But Weld County can't do anything less protective or less stringent than what the state says. So if you don't opt in, you have to follow the state anyway. That's not local control. Local control will say, Weld County, you know what's best for you. Weld County, you can set setbacks at 500 feet, but the state comes in and says 1,500, then you have to follow the state. That's not local control. So Boulder rules either way. And what does that mean financially? Well, Weld County Assessor Brenda Drones wrote about this bill. A consequence that you might not be aware of is the impact to the Gallagher Amendment. The Gallagher Amendment calculation to the residential assessment rate, which has statewide fiscal impact. We all heard what Boulder, the largest employer in Boulder, said about this bill. It has statewide impact. The calculation of the residential rate is complicated. It's a complicated formula that requires a statewide assessed value of residential property to represent 45% of the value of statewide non-residential asset value to represent 55% of the value. With the robust economy on the Front Range, there is widespread concern that the residential assessment rate will drop below the current 7.2%, thereby negatively impacting local governments across the state. Multiple fire authorities across the state went to the voters this past November to request protection from the loss of revenue from the drop in the residential rate, and many counties that are primary residential are fearful of the impact to service because of the reduction in property taxes. Oil and gas valuation resides on the non-residential side of the pie and is part of the 55% value. Early this year, the residential rate was predicted to go as low as 6.1%. The Colorado Division of Property Taxation has recently completed the preliminary study, and due to the thriving oil and gas industry in Weld County, the residential rate is predicted to be no lower than 6.9%. That prediction is calculated with a conservative value estimate for oil and gas in Weld County. If the oil and gas value is higher in Weld County, then the rate might even calculate to be 7.2%, having statewide ramifications and effect. The passage of this bill will effectively slow down or stop oil and gas growth in Weld County. Industry representatives state that the production of wells decreased 33% in 1 year. If this bill would have gone into effect last year and the oil and gas value in Weld County would have been reduced by 33%, then even with everything else remaining the same, the residential rate would be calculated at approximately 6.56% instead of the current 6.9%, or possible 7.2%. That means that governments across the state, not just in Weld County, would lose 9% of their revenue because of the decline in production in Weld County alone. This is from Weld County CFO Don Warren regarding Senate Bill 181. The fiscal of Senate Bill 181 on energy production counties like Weld County will be significant, not only to Weld County government, but all the local taxing jurisdictions in the state and county. In Weld County, over 58% of the assessed value is attributed to oil and gas. Of the nearly $850 million in property taxes paid in Weld County in 2019, over $490 million will be paid by energy companies. Think of that, $490 million just for this year. The energy companies are paying nearly $200 million in property taxes to Weld County schools alone. If Senate Bill 181 causes a decline in oil and gas production in Weld County, the ultimate impact could be that the state of Colorado, under the State School Finance Act, would have to make up the loss in revenue from other state revenue sources to keep the schools financially whole. The adverse impacts of Senate Bill 181 on oil and gas production would result in the immediate reduction of property tax revenues in Weld County. With the fracking process used for horizontal wells in the Niobrara Formation, oil wells produce their greatest flow rate when they first drill or worked over. A well's production may decline by more than half in the first year. This is a much faster drop than conventional oil wells because shale oil has a low permeability. Looking at the production in the last 3 years in Weld County, new first-year production ranged from 30 to 50 or 35% of the total production. This demonstrates without ongoing new wells or workovers, the production would drop dramatically in 2 to 3 years. Impact from the loss of tax revenues from Senate Bill 181 would be felt in a very short time. The consequences begin in a dramatic service reduction for the fire districts, water districts, and sanitation districts. The loss of oil and gas revenue in Weld County would be felt in other areas as well, well beyond the boundaries of Weld County. As already mentioned, the loss of revenue to the school districts will require the state to backfill dollars for education. Besides property tax, oil and gas producers in Weld County are paying severance tax, which funds state programs in the Colorado Department of Natural Resources and the Colorado Department of Local Affairs. The DOLA Energy and System Pack grant program funds annually between $75 and $100 million of local government projects throughout the state, including many dollars going to non-emergency producing jurisdictions. The DOLA severance tax direct distribution to Colorado municipalities and counties throughout the state was $16.2 million in 2018. Federal mining lease payments to municipalities and counties throughout the state totaled $18.7 million in 2018, and school districts received $1.6 million in 2016. Another significant state revenue that would be jeopardized or reduced in oil and gas revenues from oil and gas leases from the Colorado Land Trust. Between 2008 and 2018, the Colorado Land Trust raised $1 billion, let me repeat that, $1 billion for Colorado public schools from oil and gas leases on trust lands. Maybe Boulder can live with it, but Weld can't. And neither can Pueblo. As we heard, Everez, the steel mill, Pueblo's largest private employer, just came out opposed to this bill because they manufacture much of the pipelines needed for oil and gas. And maybe the state can't live with it. The Colorado Sun reported, worried about slowing economy, Democrats look to deploy Polis's pledge for full-day kindergarten. Yet Democrat lawmakers are considering a phase-in full-day kindergarten funding. And yet this chamber is going to kill the very industry that helps fund K through 12 education. We hear a lot of other things about public health. Well, here are some facts. EDI reports pushed back on activist alarmists anti-oil and gas impact rhetoric. A report reviewed and publicly available data from the Colorado Department of Public Health and Environment, CDPHE, including epidemiological health studies and air sample studies for Weld County, Colorado, where nearly 90% of the state's oil and 40% of the natural gas occurs. General findings of the report are that while oil and gas development skyrocketed in Weld County from 2002 to 2015, with nearly 24,000 active wells as of February 2018, data shows that the rate of death for cancer, heart disease, and chronic lower respiratory disease in Weld County decreased over this period. So let's not buy that argument. This is about health and safety. The report was released by Denver-based Energy and Death Mountain States, EID, a research, education, and outreach program. They're the ones that funded this report. Weld County numbers. Despite a growing elderly population that nearly doubled in just 13 years in Weld County, every major health indicator appeared to improve at the same time. Oil and natural gas production was rapidly expanding across Weld County. This while the number of productive wells in the county increased nearly 117%, from 12,481 by the end of calendar year 2002 to 27,063 by the same time in 2015, according to the data compiled by COGCC. According to COGCC, from 2002 and 2015, natural gas production in Weld County increased from 184 million to 552 million cubic feet annually, a threefold increase. Oil production increased nearly 12.3% times from 8.9 million to 109 million barrels per year. Active wells in Weld County account for approximately 43% of the state's total, up from 38.2% in 2006. And the county's number of active wells nearly outnumber the next 5 largest Colorado counties, aggregate active well count: Garfield, Yuma, La Plata, Los Animas, and Rio Blanco combined. These findings are consistent with the data obtained in the other areas of the county. For example, in 2001, analysis examining the effects of natural gas development in Denton County, Texas, concluded that even as natural gas development expanded significantly in the area over the past several years, key indicators of health improved. They improved as the gas drilling expanded across multiple categories studied. A separate analysis found a decline in mortality rates from lower respiratory disease in some of the largest natural gas producing counties in the Marcellus Shale region. CDPHE's findings, not necessarily bastion of conservatism as far as state agencies go. CDPHE scientists have reviewed 12 relevant epidemiological studies covering 27 different health effects in communities near oil and gas operations and found no substantial or moderate effect on any health effects on people. CDPHE ranked the majority of recent studies purporting to find a link between oil and natural gas activities and adverse health effects as low quality. So these other reports are low quality primarily due to limitations of the study, designs that make it difficult to establish clear links between exposures to substance emitting directly from oil and gas and the outcomes evaluated. CDPHE's review found that studies of populations living near oil and gas operations provide limited evidence of the possibility for harmful human effects. CDPHE's analysis noted that the individual's total exposure may reflect multiple substances from both oil and gas and non-oil and gas sources from indoor and outdoor environments. For example, VOCs, volatile organic compounds, can be emitted from a variety of sources, including oil and gas, and other industrial operations, vehicle traffic, and everyday consumer products such as nail polish, detergents, sealants, aerosol, antiperspirants, and deodorants. So I think we need to start a bill to ban those products as well. A CDPHE report that analyzed more than 10,000 air samples in the areas of the state where substantial oil and natural gas operations occurred found that levels of emissions were safe, even for sensitive populations. Based on currently available air monitoring data, the risk of harmful health effects is low. I'll repeat that, is low. Based on the currently available air monitoring data, the effects are low for residents living near oil and gas operations, with CDPHE authors concluding that this time results from exposure and health effect studies do not indicate the need for immediate public health action. Again, at this time, results from exposure and health effect studies do not indicate the need for immediate public health action. Again, from CDPHE. CDPHE statements. Former CDPHE Executive Director and Chief Medical Officer Larry Wonk has said, "There's no reason to believe that there is a causal relationship between oil and gas operations and chronic disease or cancers." Former CDPHE Director again and Chief Medical Officer Larry Wonk has noted that despite alleged claims of oil and natural gas development causing health risks, Colorado Health Department found that development has not adversely affected the health of Weld County's 200, and this has been 2016, 285,000 residents. Mr. Mike Van Dyke of CDPHE, our current report has two pieces. The first part is essentially all the air samples that we could find that were taken in the areas near oil and gas. And we really, in a conservative way, took the max concentration and the max average concentration from those data sets and compared them to what would be called safe levels by the U.S. EPA or by other states. If the EPA did not have a value, what we found was that, based on these data, there was no chemical or substance that exceeded those safe levels. Mr. Van Dyke of CDPHE again has said that the often cited leukemia study by the University of Colorado professor and researcher Lisa McKinsey had significant limitations and constituted research that suggests more research needs to be done, not research that definitively links oil and gas exposure to cancer in the age group. Former CDPHE Executive Director and Chief Medical Officer Larry Wonk told the Denver Business Journal that McKinsey's conclusions were misleading. Based on the study and other studies, data information we have to date, we find no increased risk for childhood leukemia, especially when considering the current setbacks of a minimum 500-foot buffer between oil and gas wells and homes. Wonk wrote to the Denver Business Journal, upon the report's release last February, Wonk said CDPHE saw no increase in leukemia in oil and gas developed countries, or counties, versus those that don't, and versus statewide expected averages. Why these numbers matter? Activists make unsubstantiated claims at the state legislature. Claim, a University of Colorado public health study authored by Lisa McKinsey shows that babies who live near oil and gas wells are likely to be underweight, have asthma, lower future test scores, and increased risk of acute lymphoma anemia. Fact, Dr. Larry Wonk, Chief Medical Officer and Executive Director of the Colorado Department of Public Health, said of the report, the study conclusions are misleading, and the study questions a possible association between oil and gas operations and childhood leukemia. It does not prove or establish such a connection. Claim, loads of government research centers in Colorado, state and federal, say that drilling needs to be limited because emissions from extraction process are contributing to health problems. Here's the fact. Again, Dr. Van Dyke of CDPHE, our current report has two pieces. The first part is essentially all the air samples that we could find that were taken in areas near oil and gas, and we really, in a conservative way, took the max concentration and the max average concentration from those data sets and compared them to what we would call safe levels by the U.S. EPA or by other states. What we found was that based on this data, there were no chemical or substance that exceeded those safe levels. Claim, the American Lung Association gives Fort Collins an F for air quality and oil gas illnesses. Fact, in 2014, the Colorado Department of Public Health and Environment, CDPHE, warned that American Lung Association's air quality report card was both inaccurate and misrepresented air quality in Colorado. Which brings me to the final point about the process of Senate Bill 181. This chamber talks a good game, and we talk about integrity and process and robust debate. Nothing has really exposed this fallacy than this bill. We talked, I think, enough about the process, so I'll stop there on that. I had a few other words that I was going to say, but I think we talked enough about that, Madam Chair. Let's be honest, this bill is about ramming through because this is the only chamber where supporters of energy development have a chance to stop it. Make no mistake, some will have to answer to voters, in the districts that showed their support last November regarding energy development. I've heard that 181 isn't about setbacks, completely different. That's a completely different bill. Well, that's not true. Where supporters are disingenuous, the underlying argument, 112 sold to voters because of health and safety in voters, didn't buy it and rejected the measure to destroy energy development and all the jobs, good jobs for minorities, good jobs for the people who don't want to go to in debt by $50,000 to get a liberal arts degree, good jobs for women, and good jobs for Weld County, and good jobs for all of Colorado. So I would ask for a no vote on this bill.
Is there further discussion on Senate Bill 181? Senator Foote. Senator Rankin.
Well, thank you, Madam Chair. And I just want to speak for a few minutes, as I often do, on behalf of the other Colorado, the one on the other side of those mountains that we look at every day. You know, I often think about the fact, and Governor Hickenlooper said the words rural 23 times in his State of the Union speech last year, but yet that seldom really gets translated into concern about rural Colorado. I mean, everybody buys a cowboy hat and a pair of boots, but they think they're Westerners and Coloradans, but, you know, things are really different there. And things are really different relative to this bill in western rural Colorado. And I just want to point out to you, you know, that 46% of the wells are in the Denver-Julesburg area. 36% of all the wells in Colorado in my district, the Piceance Basin, the thing I represent, which is northwest Colorado. And yet my folks tell me they don't feel they were involved in the stakeholder process. Now, You know, that's their perception, whether it's true or not. It's their perception. They feel left out. So I come back to what are the real differences? Well, I had intended to go into a long dissertation on health quality studies because Garfield County, my county, goes back 10 years. Tens of thousands of measurements that contributed to exactly those numbers. So, yes, and we need to take care of our concerned citizens. But Garfield County, you know, had a peak of 11,000 wells were drilled in about a 3-year period. During that period, those extensive measurements that you just heard about were taken. There was no appreciable impact on air quality. In fact, it got better during that period of time. I won't go into all those numbers because I think they've been very well covered. But what's the difference? Why should Western Colorado be looked at a little different? First of all, it's largely gas. It's almost 100% gas wells. The margins on a gas production are very small. They're not like, you know, the oil boom that's happening on the Front Range. So a little bit of regulation difference. We used to have tens of new drilling rigs going all the time. And you really, because a well's production is best in the first few years, you have to have new drilling to keep production going, to keep taxes up. Property taxes are charged both on production and personal property investment, as you probably know. So to keep those taxes going, you really have to have new production. So we're down to just about 4 new drilling rigs from having 90 at one time. So we have a sort of a sustaining business, but not a great business. So why is that important? Well, a 10% difference in regulation cost will in fact cause production to stop, and production, new drilling to stop, and production will trail off. So that's what my folks tell me. And it doesn't matter. It really doesn't matter that you think Weld County is exempted because they would never do local control. It really doesn't matter that you think Garfield County and Moffett County and Rio Blanco County won't be impacted. They will be. They will be because of the focus on, you know, different focus on regulation, and because of, get this, politics at the local level will become the issue. Everywhere there's oil and gas production, people will run on the basis of closing down oil and gas production. So we cannot predict the future. All we need is a few more local people elected who are anti-oil and gas, and it will affect the future in 2- and 4-year segments, which will cause, in the minds of my constituents, will cause us to have a significant impact on the taxes that pay for what we do. Let me just tell you that local school districts, looked at from a joint budget committee member, you know, we look at school finance. We're projecting a dramatic increase in local property tax contribution next year. $274 million better than the previous year. That's a lot of contribution. That offsets state contribution. We're probably, you know, one rationale says we're going to pay for kindergarten because local property taxes are that much better. How much of that is oil and gas? I think a substantial portion. I'm trying to get that number. Maybe I'll bring it back to you today sometime. That means that if that goes away, then state revenue has to replace it. That's not in the fiscal note. There's nothing in the financial analysis of the fiscal note that really looks at the impact on local property taxes of less oil and gas production. I have some school districts that are pretty interesting. Parachute, small community, by the way, which is famous for Battlement Mesa. Hundreds of homes built in the 80s to accommodate the boom on shale, which never came about. Black Sunday, closed down, everybody moved out. They're still there, great place to live, by the way, great amenities, beautiful golf course up on a hill. Their recreation district pays for all of that amenities, 95% oil and gas property taxes. The school district, 88.5% oil and gas. Rifle, big medium-sized town, you've probably all driven through there, 60.1% of the property taxes are paid by oil and gas production, and that's down from 80% earlier. Quebec, 84.6% oil and gas. Plateau Valley, 70.5%. Rangeley, 73.5%. That's a field that's been there since the 40s. So what happens? And it doesn't matter what your analysis says, it's what people perceive. It's what these oil companies, they're not oil companies, they are in fact second or third generation, smaller operators, equity investors in gas production who are waiting to see what happens. They will in fact quit drilling. It's not what we analyze, it's what they believe. They will in fact stop drilling, and the state will have to backfill those property taxes that for years have supported those communities. Is that in the fiscal note? It's not. So I've talked about the health and safety, and you know, this does go back 10 years. Garfield County started investing in sensors and measurements 10 years ago, and those have fed into this that you heard over and over. So does one size fit all? It does not. It does not. You know, and I argue this on health care, school funding. You know, there's so many issues where rural Colorado will basically dry up in the future because people don't have access to health care. They won't have the property taxes to support their parks and their schools. So were the stakeholders involved? They don't think so. Will the political issues cause dramatic uncertainty as we elect different county commissioners? Yes, because now local control, or you know, this local involvement will mean that we will have folks trying to close down the industry throughout the state in various pockets. So how do we consider, you know, what should we do about western Colorado? Well, this bill doesn't do it. This bill adds a layer of supervision, health analysis that has already been accomplished. We've already done all that. We've already got through all that. We've been through 2 generations of owners, and now we have a fairly stable but marginal industry in western Colorado, which will in fact go away in the minds of the people who live there. So, you know, maybe I'll come back and talk some more about specific issues county by county, but I wanted to just give you an overview of how western Colorado views this bill.
Senator Foote.
Thank you very much, Madam Chair. And I do want to register my agreement, actually, with something that my good friend and colleague from Weld County said earlier at the well, which is that just because you say something over and over again doesn't make it true. And I absolutely agree with that statement, and I also think that it really applies nowhere better than in the oil and gas debate. Just because we're hearing outside of the building that this would be a ban doesn't make it true. Just because we're hearing that this would be a moratorium doesn't make it true. Just because we're hearing that this is the same as Proposition 112 doesn't make it true. If we're hearing things about how this bill would cause economic harm, indeed even economic Armageddon to the state, doesn't make it true. I have in front of me a mailer that talks about oil and gas. It's entitled, "A Looming Threat to Colorado's Economy." That's on the front. And then when you look in there, it talks about new job-killing rules, a radical plan that changes Colorado's oil and gas regulations. These changes could cripple our economy, this mailer says. When the drilling stops, it says, the paychecks stop, throwing 10,700 or more people out of work for months at a time. Families suffer and our economy takes a hit. It goes on to say a report done for a Colorado oil and gas trade group says proposed new state regulations could cost natural gas customers billions of dollars over the next decade. So I would ask rhetorically if anyone can guess if this flyer is dealing with Senate Bill 181. The answer is no, this flyer is actually 10 years old. It deals with regulations that came down in 2008 that were claimed to be job-killing regulations. Mailers went out claiming this, that 10,700 jobs would be put at risk. You know what actually has happened, though, since 2008? This state has seen an addition of 20,000 new wells. Oil production in this state has gone up 453% since these supposed job-killing regulations came into place in 2008. What we heard about Senate Bill 181 after the bill was introduced on March 1st was on March 2nd, we heard from industry opponents saying, really, in effect, we need more time to study the bill, but we know it's going to kill jobs. They apparently know enough about it at that point that they say it's going to kill jobs. But here's really what the bill does. It reforms the way that these processes are done in the Colorado Oil and Gas Conservation Commission, so that health and safety comes first, not an afterthought. Not an afterthought. So what that really means is there's a few sites in the past that may have looked a little different under these new rules. Putting a large industrial operation 350 feet away from an elementary school soccer field near Greeley may not have happened under this bill. Maybe it would have gone somewhere else. Putting a large industrial operation 500 feet away from a mobile home community on the western slope may not have happened under this bill. But we heard in committee, in the Transportation and Energy Committee, testimony from Weld County in particular, saying, we don't want this local control. And in fact, Weld County testified to the fact that they make up about 75%, it may be a little bit more actually as I remember it, of the production and also the new production. Out of 6,000 pending permits that we have, I do know that 77% of those are from Weld County. They don't have to take advantage of the local control delegation. They don't have to do that at all. So what that means then is that the rules from the COGCC will be in effect. Health and safety comes first. And there's going to be new air quality rules as well. So I guess I ask again rhetorically, if health and safety comes first, and we do hear from the industry that they prioritize health and safety as it is, then what's the problem? What is the problem? We're still going to have permits granted from the state in Weld County or on the western slope. That's going to happen. We know this. But I think also what will happen is the COGCC may be able to deny a permit if they think that it's too close to a school or too close to a neighborhood or in the middle of a neighborhood because health and safety is prioritized. That's what it's going to do. And for those communities that choose to use local control like they have local control on everything else, they will be able to put into place what their communities think are appropriate. If communities in the western slope don't think it's appropriate, or Weld County, or Arapahoe County, or wherever, that's fine. They deal with that in every other type of land use. But to the extent that the local communities do take advantage of this local control that they have with oil and gas, it still has to be within reason. It has to stand up to challenge in court. So they can't just do anything they possibly want. Now, I'll tell you that this bill doesn't go nearly as far as many of my constituents want, but it makes a big improvement, and the reason why I'm supporting it, even though many of my constituents are opposing it, is because it makes a big improvement and puts health and safety first, which is what I think and what many think should happen. That doesn't mean that permits are going to be denied en masse. It means that they're going to look at it through a different lens. We're not promoting oil and gas as our first and foremost mission. We're making sure health and safety comes first. If in fact that is the priority of the industry, which they always say it is, I'm not sure how much is really going to change. But I do think we're going to have a new lens and a new analysis that will make sure some of these most egregious siting decisions that have happened over the last 10 years don't happen again. Thank you, Madam Chair.
Senator Quorum.
Thank you, Madam Chair. I would like to address a couple of things here. My good friend from Lafayette. I do remember 2008. Hard to believe that I do. I'm old. I'm probably about the oldest, second oldest one in this room. I look older than anybody. I'm high mileage. But in 2008, we were looking at a booming economy in western Colorado. What has turned out to be the representative from Northwest Colorado's district, the second largest oil and gas reserves in the world. And we were all flying pretty high. We were talking about the growth in our communities and how we were going to get an 8th congressional district. We were excited. We were going to have more representation in D.C. But what happened is we had some regulations that those who own the resources, and keep in mind, resources do not go away. They're there till they're produced. The people that produce them do go away. So what I had is my friends, neighbors, that were working the oil and gas fields in western Colorado. I didn't hear from them because many of them went to Pennsylvania. They went to Texas. They went to the Dakotas because the regulatory environment was more friendly. And it caused a great deal of problems, bankruptcies, foreclosures on homes, families being disrupted because the breadwinner had to leave home. Marriages were broke up because of the stress. I don't know what's going to happen with this if this passes, but I do know we are the land of unintended consequences in this building. What I do know, this could have devastating effects on the economy of rural Colorado. I can't tell you how much. I can guess with you. But I know there will be effects. Jobs lost. We're talking maybe up to 120,000 jobs in the sector, 2030. 257 billion in lost GDP from 2020 to 2030. But let's talk about what we do know. We talk about in our times when we're doing well, severance tax does well. What do we do in the General Assembly when we find a cash fund that we think is ripe? We sweep it. We have swept the severance tax for over $300 million. And I'm sure it won't be the last time that it's swept. It may be the last time it's swept if this passes, because I don't think we will have a severance tax. And let's just talk about how that affects the people in my district. And I'm going to go back to 2010 to 2017. Montezuma County, in DOLA, severance tax dollars, received $3,392,000. The biggest ticket item that I can see on that was 2016. City of Cortez got $2 million for a firehouse. La Plata County got $9,387,602. I'm sorry, that's not chump change. That's real dollars in small communities. A county of less than 60,000. That's a lot of money. A lot of things are affected. Dolores County, small county, I believe it's less than 2,000 people in Dolores County. In 2016 alone, they got $2 million. San Miguel County, where we're getting a lot of snow right at the moment. It's greatly appreciated. $2,653,000. Once again, a county of less than 5,000. That's not chump change. That's real. San Juan County, which you can't get to right now, barely, because of avalanches. Got Red Mountain Pass between Ouray and Silverton. Has been closed for several days. They're saying a week, but with the new snow coming, probably another week on top of that. Snow depth at 60 feet in some of those roads. They also got hammered this summer by forest fires. But $467,000 means a lot to a small community like that. City of Ouray, the north end of Red Mountain Pass, gets $1 million. Montrose County, City of Montrose, my home county, $3,881,000. I just got an email this morning from my recreation district where they just got another $500,000 grant from DOLA. DOLA dollars are real. It comes from severance tax. Let's talk about schools. My district. We'll go through, let's talk about federal mineral lease. Federal mineral leases produced in the state $18,700,000. That's not chump change. Some of my districts that I've talked about are affected by that. The school districts, federal school districts, that was for the county and municipalities. We get $1,590,000 for school districts. These are schools, many of which operate on 4 days a week because they don't have the resources. Take that away from them. See how you're going to backfill. Severance tax is real, but the real part that concerns me, we all talking about affordable housing, everything we're going to do for rural Colorado. But if you give them a house, you pay the utilities, you pay the taxes, they still can't afford to live there because their employment opportunities are taken away. I have read a couple of articles. Someone I consider a friend, former Secretary of the Interior Ken Salazar, said we need to put the brakes on this. Wellington Webb said we need to put the brakes on this. I am all for clean air, clean water, a healthy environment But a healthy environment cannot survive without a healthy economy. And I really feel that the unintended consequences of this action, I think we need to slow it down. I'm going to follow the example of my friends that I quoted. Because we cannot have a healthy economy and a healthy environment. They have to be together. And if we destroy our economy, the unintended consequences, we will also be destroying our environment. I ask for a no vote on this.
Thank you. Seeing no further discussion on Senate Bill 181, please proceed.
Thank you, Madam Chair. I'll just be speaking to a couple of what are probably relatively minor points on this bill compared to what we've heard today, but some of that happens when you spend 12 hours of quality time with one bill. Forced pooling, and of course, whether that's minor or not depends on whether you're the minor or majority owner in a pooling system there, but thanks to a chain of events that began decades ago when railroads were given every other section of land, this particular provision would put one company in the driver's seat for most of the DJ Basin. Forced pooling regulation in Colorado may need to be revised. I'm not an expert in it, but I do know for sure that it's not good to give one company the keys to everybody's oil and gas resources in the DJ Basin. And then on a really minor point that you kind of pick up after sitting there for hours, Senate Bill 181 also requires the hiring of 2 deputy directors. And we know along with that comes the necessary admin, the vehicles, the support, the training, et cetera, et cetera. Do we not trust our department heads to make the right decisions in hiring who and what they need for the mission that we've given them to carry out? Will they have to come to this body sometime in the future when the mission changes, when the workload changes, when things are different out there in the field? Will they have to come back to us to make changes in their personnel? This provision may well be the least of the onerous provisions in this bill, and if it is, that should really concern us as well. Can the industry be safer, cleaner, more neighborhood friendly? Absolutely. But this is not the right bill to accomplish that. I would ask for a no vote on 181.
Seeing no further discussion, Senator Cook. Senator Cook, you've already been recognized.
Thank you, Madam Chair. We heard that this is not a ban on oil and gas. I would like to give my argument as to why I believe it is a ban on oil and gas. Senate Bill 181 is currently written can make it impossible for the Colorado Oil and Gas Conservation Commission, COGCC, to effectively regulate oil and gas development because the bill creates a standard that is potentially could not be met. The same standard could subject the agency to a flood of lawsuits. That is because the new legislation would require the Commission to regulate oil and gas in a manner that protects public health, safety, and welfare. Everywhere the bill directs the Commission to protect against the adverse environment impacts on any air, water, soil, or biological resource resulting in oil and gas operations. The word protect is not defined in the bill, but inevitably anti-oil and gas groups will argue that protect means to avoid any adverse impact on public health and safety. When the Commission starts rulemaking to implement Senate Bill 181, it will face arguments that the Commission may not issue any permits until it can demonstrate the impossible, that oil and gas development will have no adverse impacts. Even if the Commission does not adopt that definition, virtually every permit will be challenged at the Commission and then in court on those grounds. Permitting will grind to a halt while the administrative and judicial process runs their course. To me, that is a de facto ban. Moreover, the bill deletes the current requirement that COGCC take into consideration the extent to which its decisions are cost-effective and technically feasible for operations to implement. This bill strips these requirements from the Oil and Gas Conservation Act, even though those standards are in every other environmental regulation. For example, the identification of remediation alternatives for hazardous waste and waste sites requires the consideration of economic and technically feasible alternatives. The Water Control Commission is required to consider the technical and economic feasibility of treatment techniques when issuing water quality standards, establishing water control regulations, and issuing permits. The Air Quality Control Commission, when promulgating emission control standards regulations, must consider the availability, technical feasibility, and economic reasonableness of the control techniques required. The Mine Lease Reclamation Board is required to consider the economic reasonableness and technical feasibility when coming up with rules governing mining operations. The stripping of the cost-effective and technical feasibility standard in the bill, coupled with the fact that COGCC must regulate with primary goal of preventing any environmental impacts, will make it impossible for COGCC to effectively regulate oil and gas development. To me, that is a de facto ban. Thank you, Madam Chair.
Senator Lundin.
Thank you very much, Madam Chair. We've heard a few of the members speak about some of the financial consequences. I would like to, at this moment, confine my comments to two elements: the economic consequences and then the tax effect consequences of this. In the original fiscal note, and even though I realize we are not rushing through this, you all just within the last hour or two have received a new fiscal note. I haven't had time to fully digest that, but I want to call out a few of the important facts that came from the original fiscal note. It says in the section of the fiscal note with regard to state revenues, the measure's revenue impact will also depend on the type of regulations, and there's a significant amount of unknown responses to those types of regulations, because we're going to rebuild the regulations at the state level, and those are going to be rebuilt by a newly composed commission with a lot of new personalities and some dramatically, significantly different perspectives and agendas as those regulations are rebuilt. So what those regulations look like at the state level, we cannot know, we do not know. But then we have the added complexity for the folks who are writing the fiscal notes to try and figure out what the local regulations might look like as well. So you've got these two layers of additional regulations. So it says here, the measure's revenue impacts will also depend on the type of regulations, if any, that the state and local governments enact, and the effect those regulations have on the overall production of oil and gas resources. And then it attempts to give us the bands, or the bounds of the band. Okay, so the logical question any policymaker would ask, any business owner would ask, anybody who is thinking and sentient and engaging in this would say, well, what's the low end of that? What's the positive minimal impact? And what's the high end of that? What's the positive negative impact, or the potential negative impact? And the response to that question from the fiscal analysts, who, again, I commend them for their work, is, for example, an outright prohibition of oil and gas development will reduce overall severance tax revenue and the oil and gas conservation mill levy, since the resource must be removed from the ground before these taxes may be levied. So that means it goes potentially to zero in terms of the tax dollars that would be coming in from those previously robust channels of tax revenue flowing into. I'm going to move that mic, I keep hitting it. I'm too demonstrative here, perhaps, in my speaking. The currently robust flow of tax dollars coming in to the state and to the local governments. And let's know that means, when we talk local governments in this instance, we're talking about fire departments who depend on this for the public safety of the people. We're talking about schools that depend on the revenue and property tax dollars that come in. And I'll get to how significant those flows are in a couple of minutes. But right now, I'm confining my comments to the fact that we just don't know what this is about. The fiscal note then goes on to say, other state or local restrictions may still allow oil and gas developers to access the resource and will have less impact on the state revenue, since those future conditions are unknowable. The precise change, says the fiscal note, in state revenue cannot be estimated. We do know one thing, however, It's not going to have a positive impact. It's certainly not going to expand the revenue that flows in. We know it's at best case neutral, non-revenue enhancing, non-beneficial to the economy. More likely, it has a slight to extreme negative consequence. And so the folks on the ground, and we heard testimony from an actual oil and gas CEO who is part of a company that he described as a Colorado-built company, a Colorado-owned company, a Colorado-serving company. It's a Colorado company through and through. And their current plan is, based on a response to this bill as proposed, is the $625 million in CapEx, the money they would have spent to build the elements of industry that in fact provide jobs and quite frankly provide the power to keep our economy moving. Their plan, based on this bill, and this is in response to some of these questions that have been asked before, what is the potential impact? There is no potential impact. You're shadow boxing, you're fighting with ghosts. The reality is no. Judgments are being made today based on this, and this particular company says instead of $625 million in CapEx funding, they're going to cut that by 53%. A $20 million payroll that was going to go to $30 million anti or prior to this, before this bill. In fact, they do not know where it's going, but they know it will not stay at the $20 million level. It will go down. And so the reality is we're seeing a clear economic effect, and we heard about it in the Finance Committee as this bill was heard just prior. Another element, a financial analyst for an investment company came in and said the risks of not producing oil and gas in Colorado are already, the uncertainty baked into our economic future based on this bill, are already creating price compression in valuations. That means that the money that would be spent to build out the energy to power America, the energy to keep America safe, the dollars driving that are not coming to Colorado. They're going elsewhere, where they get better valuations, where the environment is not so uncertain. So that has a negative impact that reverberates through our economy. At the end of the day, translates into lost jobs, lost opportunities, and less money in people's paychecks, and less potentially beneficial aspects of good-paying jobs in Colorado. And here's the thing. As you look at different industries and different elements of our economy, some elements have a big multiplier effect, meaning when that particular element of industry or that sector of our economy spends $1, it gets multiplied. That dollar gets spent once, and it gets spent again, and it gets spent again, and it gets spent again. Other elements of our economy are very consumptive in nature. The dollar gets spent, and the story's over. There is no multiplication associated with that. When you look at those economic realities, we have, in this conversation, both ends of the spectrum. The heavy industry of oil and gas, of energy production, is one of those elements of the economy that has a significant high multiplier effect. The regulatory burden of government and the expansion of government is on the opposite end of the spectrum. It has a 0 or close to 0 multiplier effect. It lands like a thud. It, in fact, doesn't multiply again. So those are some of the elements with regard to the economic impact. Let me give you some thoughts that were gathered from folks who are a whole lot smarter than I am and project what some of those potential economic consequences could be. A projection. This is potentially a moderate projection. If SB 181 shuts down 50%, half of the new oil and gas production, the impacts by 2030 would be 120,000 fewer jobs across all sectors. Part of that will be in the oil fields themselves. Part of that will be the multiplier effect of the other jobs that support that will not happen. Over $8 billion in lost state and local tax revenues from 2020 through 2030. And over $158 million in lost GDP, gross domestic product, for the state from 2020 to 2030. So 120,000 fewer jobs. And I won't even go to the upper bound. You've heard that just because the bill doesn't say moratorium or prohibition, it therefore can't possibly exist. The reality is, you don't have to write the word into the bill to get the economic impact, get the economic effect. You can get a prohibition or a partial prohibition without the word ever appearing anywhere. So you don't have to call it that to have the economic impact of that. Let's turn now to some of the financial consequences for state government, for local governments. The reality is we rely in funding our K-12 education system, this is something I know a little bit about, we rely very heavily on local property taxes. The senator from the Western Slope, I don't see him, was speaking about this earlier. The reality is when the local share of the financial formula is funded by property taxes, and those property taxes are paid out through oil and gas. When school districts, and this is where the rubber meets the road in this building and across the street as the budget gets developed, when that local share of money that's flowing in a robust way today, when that's diminished, it has to be made up somewhere. It has to come from somewhere else. And that means we're going to crowd out other legislative and policy initiatives. The priorities you may have potentially with this bill are on the chopping block. We all know what it's like to scramble for $1 million here, a couple $1 million there. $10 million is a really big ask if you've got a really good piece of policy you want to run. The effect of this particular bill is in the magnitude of hundreds of millions of dollars. Think how many $1 million asks you will not be able to make with your legislative agenda going forward. Think how many $10 million asks off the table, because we are backfilling what local taxes would have paid into the public education space, because that is a priority for us, that you will now not be able to put into your other legislative initiatives. And there's a perverse and complicated relationship between commercial property tax rates and assessed value and residential property tax rates and assessed value that this bill unintentionally, I believe, but nonetheless, as a matter of fact, will have an incredible negative effect. We heard from an assessor who spoke about specifically their county, Weld County, a county where oil and gas matters. This is their conclusion. And listen carefully, this is not just about Weld County. The passage of this bill will effectively slow down or stop oil and gas growth in Weld County. Premise, assertion that they're making. I happen to agree with that particular premise. Industry representatives state that the production of wells will decline by 33% in 1 year. If this bill would have gone into effect, says this assessor who really ought to know the details, last year, and the oil and gas value in Weld County would have been reduced by 33%. Then, even with everything else remaining the same, the residential rate would be calculating at approximately 6.5% instead of the 6.95% or possible 7.2%. But here's the money shot. Here's the thought that matters to you. The effect of that for Weld County and each one of the 63 other counties in the state, that means that governments across the state, local governments, we're talking fire districts, we're talking school districts, we're talking right in your community, not just Weld County, would lose 9% of their revenue because of that production decline in Weld County. That's the effect that this tax balancing act may have. So let's, again, from the good offices of the folks who do our fiscal notes, let's answer the question that was asked by the senator from the Western Slope. He said, I don't know how much of that property tax money, that money that's going into schools currently, how much of that is coming from the energy industry. We have an answer, at least in part. For fiscal year 2018-19, property taxes collected for school finance in Weld County were about $147.1 million. There are 16 school districts that receive funding from property taxes collected in Weld County. combined with specific ownership taxes and other local resources, the local share for those 16 school districts was about $156.1 million. So to my prior point, if you've got a $1 million legislative priority ask that you have in front of the Budget Committee, you need to pick that priority up right now, go find another 155 initiatives just like that, and tell the colleagues that have those other initiatives, sorry, off the table, we don't have the money flowing in to do that. Oh, I misspoke. Let me be clear.
Senator Lundin, are you referencing the fiscal note for Senate Bill 181?
Yes, ma'am, I am. Thank you, Madam Chair. In fiscal year 18-19, and this was the question to the answer to the question from the senator from the Western Slope, 58% of all of that assessed value came from the energy industry. So, quick math, the rule is never do math in public. I'm going to try and do it here with the back of a napkin wag. We're talking about $85 million, not $156 million. So you only have to take your $1 million legislative priority off the table and go find 84 other priorities like that, because that's how much money we're going to have to backfill into the education funding from the state because it is no longer being provided by local governments. One other thought on that. There is a really big ask for education happening right now. And that really big ask is full-day funding for kindergarten. The reality is there's a wind in the sail of that initiative right now. That initiative has the support, encouragement. It's a policy priority for the governor. I think it's something that is gathering steam in this building. But it is completely reliant on property tax dollars flowing in. It's reliant, unless we come up with other means of funding it, it is reliant on exactly what this bill is setting up to disrupt. So in this moment, prior to this bill, where we have the good economic circumstances, the high tax flow revenue that's flowing into local coffers, we can have a conversation about $231 million for kindergarten, full-day kindergarten. But we're setting ourselves up that a year or two or three down the road, that kind of request is off the table, not a possibility, because the funding sources that in fact provided for that will be curtailed, perhaps be dried up and blown away. For the preservation of a healthy economy, and I agree, we've heard from this well earlier today, that safety is in fact rooted in healthy economic circumstances. I think that in a perverse way, the intended consequence of this bill may in fact come back around and bite itself because we damage our economy in ways. Certainly we know that it will have negative impacts in the lives of individuals who will likely lose their jobs. Difficult circumstances for them. But to the folks here in this building, where we count dollars closely and we look at the money that the taxpayers are contributing to us to do the good work that we hope to do on their behalf, be aware. This bill sets us up to, if not kill that golden goose, certainly choke it in a way that is not attractive nor productive. Thank you, Madam Chair.
Mr. Majority Leader.
Thank you, Madam Chair.
Excuse me, Senator Rankin, I recognize the Majority Leader.
I'm sorry.
Thank you, Madam Chair. I move that the committee rise, report progress, and beg leave to sit again.
Motion before the committee is to rise, report progress, and beg leave sit again. All those in favor say aye. Aye. All those opposed say no. The ayes have it. The committee will rise, report, and beg leave sit again.
didn't do any actions. There's no actual report, just.
Okay. Sitting in the back there, I don't know if it's appropriate to do now. Do you remember?
Do you know what you're saying? Because we're not moving any reports, so they'll go down and tell you what to say. Senate will come to order. Members, would you please take a moment to recognize Representative Wes McKinley, who's here joining us today. Senator Danielson.
Hey, oh, whoops. Thank you, Mr. President. There's nothing to report. There is no report.
Having no report at this time, Mr. Majority Leader.
You're up, Mr. Majority.
Thank you, Mr. President. I move that the Senate recess until 1:30 p.m. today. Members, we will not start promptly at 1:30 p.m., but sometime between 1:30 and probably 2 p.m. at the latest, we will do a call, but we cannot meet prior to 1:30, so I'm just saying 1:30 for now to be safe. It'll probably be more likely 1:45. Listen for the call around 1:45.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the Senate will stand in recess until 13:30 today.